May be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant. Assistant State Attorneys. Okay, are there any preliminary matters we need to bring up? Okay, Mr. Ashton.
Good morning.
Morning.
I would like to address the discovery issues as to the Mr. Richard Eichenblum, who was addressed briefly yesterday. We completed his deposition yesterday afternoon. I provided the court with a copy of that, a very rough copy that we received by email today. I believe that counsel has received it as well. Upon review of the case of McDuffie v. State, found at 970 Southern 2nd 312 at the court's suggestion, at this point, Your Honor, we believe that a discovery violation clearly has occurred. We do, however, believe that exclusion of the witness outright is not necessary, and we would not be requesting that the witness be prohibited from testifying. We don't believe that that would be in the best interest of the defendant or in the future of this case. We would, however, request that sanctions be imposed in the following way. The court has already addressed that it will, in all likelihood, address contempt issues at the close of the trial, and we would suggest that this is an appropriate matter to be included within that. We have, in the deposition, we have been able to overcome procedural prejudice in most aspects of his testimony, and I believe that I will be able to cross-examine him effectively. The only area that I cannot is one particular opinion of the witness. The witness proposes to provide an opinion which is based on the scientific principle that DNA is recoverable from decomposition fluid. This is discussed in the witness's deposition starting at page 51 going through page 62. This is an issue which, had it been properly provided, would have been the subject of a pretrial Frye hearing. The witness in his own deposition acknowledges that that scientific principle is not based upon any peer-reviewed research. It is not based upon any research at all. He would accept that principle based simply on some anecdotal experience of his own. Obviously, at this point, the state is, because of the late discovery, and I will comment that the deposition also reflects that the opinions that this expert has formulated were formulated on Saturday, that he was never informed of the court's order about preparing a report containing all the opinions, and that he basically indicated in the deposition that he flew over here on Wednesday and didn't formulate the opinions till lunch on Saturday. So what we would request, number one, is that that portion of the witness's testimony in which he would give opinions about the lack of DNA results from the carpet stain be excluded because of the procedural prejudice that the state is deprived of the opportunity to have a full and fair Frye hearing. There is substantial indication in the deposition that the information would not survive a Frye hearing, that the proponent, being the defendant, could not establish the general acceptance of that principle. And under I think the most similar holding is actually the Cybers case, which the defense has argued at length in Frye hearings at 841 Southern 2nd 532, which basically, again, as the court is well aware, stood for the proposition that if a scientific principle is based in Cybers on the ability to obtain a certain chemical from a embalmed body was not scientifically accepted, then the opinion could not be offered. And again, obviously we can't have a full Frye hearing, we don't have time, but I request that that specific opinion be excluded as a sanction of discovery. Again, to remind the court, and I'm sure the court remembers, the defense has already had one witness testify about this issue. Ms. Subert from the FBI was allowed to testify about the effects of decomposition on various fluids and whether you might or might not be able to get DNA. So they have offered that testimony already. So I would object to this new expert giving an opinion based on a non-accepted scientific principle. Aside from that, we will be able to address in cross-examination the remainder of his testimony. We would request, though, an appropriate instruction to the court at the time the witness testifies. I've handwritten a suggestion, which I'll read into the record, and the court wants to have it. If you can read my writing, I'll hand it to you, which would say, in essence, all reports of experts were required to be provided well before the beginning of this trial. The report of Richard Eichenblum was not provided to the state until Sunday, June 9th. I'm sorry. Until Sunday, June 19th, 2011. You may consider this fact in judging the credibility of the witness's testimony, and in determining what weight it should be given in your deliberations. We feel that that is a fair, balanced approach to the discovery violation, and the issue of contempt would be left for another day. Thank you.
What says the defense?
Good morning, sir.
Good morning.
I filed a response with the court on December 15th of 2010, where Mr. Eichenblum where the court had asked that I explain what he may be called to testify. And I listed his CV, Mr. Eichenblum's CV, field of expertise, as being DNA, crime scene analysis, and trace recovery. On sentence 3, I informed the court and the prosecution that if Mr. Eichenblum were called to testify, he would testify in the areas of DNA, crime scene analysis, and trace recovery. Sentence 4, he's reviewed all reports and photographs taken at the recovery site and personally inspected many of these items, and that was during the evidence inspection. Number 5, if Mr. Eichenblum were called to testify, the substantive facts that he would be expected to testify would be to rebut any false claims raised by the state's forensic experts dealing with DNA, crime scene analysis, or trace recovery. Until that occurs, it is difficult to give a complete summary of his opinions and the grounds for those opinions. I raise that because this is a very complex case, especially forensically. What I would like Mr. Eichenblum to testify to would be the issues raised about degradation of DNA. And I think this notice should be sufficient to put the state on notice that that's an issue that he will be testifying to. The opinions, this is completely separate than the issue we had with Dr. Rodriguez, and I'd ask that the court consider it differently, and I submit this for your Honor's consideration. As these issues came up, and we knew that we wanted to, and when your Honor gave me the example of his own personal experiences, I wanted to take that benefit, the benefit of that knowledge, and apply it in this case. I'm sure, as Mr. Ashton had mentioned, these opinions were formulated on that Saturday because these were issues that I asked him at that time. I knew we were going to take depositions, and I thought of taking full advantage of the fact that we were going to take depositions and perhaps be able to expand issues that he may be called to testify to. It's not to create any gotcha moments or anything like that. So what I would suggest to resolve this entire situation as it relates to Mr. Eichenblum would be to call Mr. Eichenblum to testify solely to those issues of DNA having to deal with degradation. While I would love to argue about the whole point of exclusion that Mr. Ashton had brought up, the issue about the being able to collect samples from decomposition fluid, Ms. Subert testified to that, and no objection was raised by the state, and they never asked for a Frye hearing then. But yet, as Mr. Eichenboom testifies, in order to try and inflame the court into thinking that sanctions are warranted here, he creates this ruse of an issue saying that we need a Frye hearing and we've got all these problems and all these issues, when the fact of the matter is it's not so. So in efforts to move things along, I would propose to the court, and I don't know if this is acceptable to Mr. Ashton, but he certainly has had plenty of notice of which, and that is to solely limit Dr. Eichenboom's testimony as to explaining DNA, specifically low copy number DNA, which Ms. Subert, unfortunately, the FBI doesn't do that type of DNA, and this witness is uniquely qualified for that, which of course the state knows, and explain issues of degradation. Generally speaking, I could give them hypotheticals as it relates to some of the issues in this case, and then we can move on with this trial. I know Mr. Mason will address some other issues dealing with the other witness, but I just kind of wanted to propose that to the court and see if we can resolve this issue and just move forward.
Thank you.
Brief response, Your Honor?
Yes.
Just very briefly, just to point out that the state did not offer any DNA evidence in this case. The DNA evidence was offered by the defense. So the defense is, in a sense, rebutting their own witness in that sense. The other is, I'm not sure I understand counsel's proposal. If his proposal is that the witness will not give an opinion about the ability to get DNA from decomp fluid, then that's acceptable to me. As long as he's not going to make any opinions about the carpet sample, then I don't have a problem. That was the area where I felt that there was procedural prejudice. So if that's counsel's intention, then that resolves that issue. I do not believe, however, that the instruction, I think, would still be necessary, and I believe the other proceedings later in the trial would also still be necessary. But as far as the witness goes, if that's what he means, that's fine.
Let me ask both sides to address this. At some point, the court granted the defense's motion to have certain items of evidence at taxpayers' expense tested for DNA, and it was sent somewhere, I believe, up north, correct?
Yes, sir. National Medical Services Laboratory in, I think, New Hampshire.
Okay.
Pennsylvania, excuse me.
And what items were tested?
I believe that the shorts and the bag were tested. I don't believe that the tape, I'm sure, was not tested, but I'll refer to counsel if anything more than that. I think it was just the victim's shorts she was wearing and the bag that she was found in. That was it, as far as I know.
What happened to the tape and what happened to the carpet samples?
The defense never requested that those be tested, to my knowledge, as I recall the motions filed.
Okay. And he's proposing to testify about the possibility of DNA on duct tape.
Yes, sir.
And he wants to testify about carpet and the ability to test carpet for decomp fluid to extract DNA from that.
That is correct. According to the deposition, the witness was not aware of which items were requested for DNA testing or what the results were. He apparently was never informed of which items were being requested or what the results were, according to his deposition.
So in other words, he was not aware that those items could have been tested for DNA and they were not.
I believe he would say in his deposition that he believes they could have been tested, but was unaware that they were not.
Okay.
May I address those questions?
Yes, sir.
With the court? We're talking about completely different types of DNA testing. The testing that he does is low copy number DNA type testing. They utilize a special kit called the mini filer that allows you to get DNA from very, very, very minute amounts. That type of testing is unique. We requested that they be allowed to test items, and that, of course, was objected to by the state, and the state granted or sustained their objection and denied our opportunity to have him test these items due to a very specialized subfield of DNA that he is one of the pioneers of. In the alternative, we were granted the ability to test certain items by an ASCLD certified lab. We asked specifically for a different type of DNA for those items because we thought it would probably be the most likely scenario for us to be able to accomplish getting something of benefit to the defense. And that type of DNA was not low copy number DNA, it was YSTR DNA.
So are you saying that there's no certified lab in the continental boundaries of the United States that does low copy DNA testing?
My understanding is that the only crime lab currently doing low copy number DNA is the New York City Crime Lab. And I am not aware of any other ASCLD certified labs that do low copy number DNA in the United States. In Europe, it's quite prevalent. Of course, DNA was actually discovered in Europe and developed in Europe, and they're, by many people's estimations, a little bit more advanced than we are here in the United States as far as low copy number DNA is concerned.
And has low copy DNA been FRI approved yet?
It has. Well, let me rephrase that. It has been used in cases out throughout the United States, but whether it's been FRI tested here in Florida, I can't say.
According to the witness's deposition, the procedure he uses is a standard procedure developed in other laboratories. He did not indicate that he does any. He explained that low copy number is simply additional replicating runs of a traditional PCR method. Instead of running it 24 times, you run it 30 times. He did not indicate in his deposition that this is a procedure which is unique to his laboratory. He did not indicate in his deposition that this is not done in the United States. And I'm not aware of what counsel is referencing about the inability of United States laboratories to perform these DNA tests. This is the first that I've heard of that. So, for what it's worth.
That's absolutely not true. There's a special kit called the mini filer. I'm certain Mr. Ashton's aware of it. It's not just doing extra runs in the PCR process. It is a specially designed kit, and it is, how prevalent it is in the United States, it's still up and coming. From my understanding and my studies of DNA, I can represent that to you, and I can say this much. I have studied quite a bit on this area, and Mr. Eichenboom is well known throughout the DNA community as being a pioneer in this area. Whether he does something a little bit different, other than the amplification process and using these specialized kits, and more importantly, the type of trace recovery that they utilize. And the witness is here. He can testify as to the uniqueness of what it is that he does that's different. But We would certainly object to any, especially since we are conceding and willing to stick to areas that are and should have been very well known to the state, to anticipate Mr. Eichenboom's testimony, for which they did not take his deposition up until recently. We would object to any specialized instruction trying to punish the defense in any way other than what we've just discussed.
Okay. Anything else?
Nothing further, sir.
No, State of Florida, sir.
Okay. The court hearing arguments of both the state and the defense will grant the state's request for the instruction, and at this time would prohibit the testimony concerning the possibility of testing by DNA analysis of the decomposition fluid in the trunk. Now, what the court would do out of abundance of caution, if since it looks like we're going to be doing this for the next 2 weeks, if you want to schedule a Fry hearing, giving the state at least 1 week's notice, I will consider doing that to see whether or not it would be admissible. But for the time being, it is not going to be permitted as a sanction for not disclosing it. But I will not permanently shut the door, but give you an opportunity upon proper notice. I will permit anyone that has an expert to testify by video conferencing if you want to conduct a Fry hearing. Okay. Yeah. Hope I can read your writing.
Your Honor, we would object to the state's. We hadn't been given a copy of the proposed instruction. I just looked at it now.
You have an alternative instruction?
We didn't know they were going to be requesting one. We can prepare one.
Who's going to be your first witness this morning?
We can, to delay the issue, call Dr. Jane Bach, and in the meantime we can prepare. Hold on, I'm getting lip reading. I believe we can call other witnesses to, in the meantime, while we prepare instruction.
Okay, prepare one, have someone kind of give it to the court deputy, give to me, and then between the two of them, I will fashion something on my own.
Yes, sir.
Okay. Anything else, folks? All right, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay, does the state recognize the presence of the jury? And does the defense? The defense may call their next witness.
The defense will call Jennifer Welch. Please stand, raise your right hand, and answer out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
My name is Jennifer Welch, W-E-L-C-H.
You may proceed.
Thank you. Ms. Welch, I believe you've already established that you are a CSI Orange County crime scene investigator. Is that correct?
Yes, that's correct.
Okay. All right. And did you author a report dated February the 1st, 2009, and the Bates stamp would be 3433?
I don't have one with that date on it.
Do you have a report that indicates the end-of-day observations with regard to clearing of the scene December the 12th through the 14th?
Yes.
Okay. All right. Can you explain, or if you need to refer to your notes, that's fine, what your observations were?
Yes. Yes, on that day, December 14th, 2008, at the end of the day, I made observations that during the period of December 12th through December 14th, with December 12th being the first day of searching and clearing the scene, that the areas had been cleared of leaf litter and vegetation from approximately 0 to 4 inches. And around the trees and the tree roots where the crevices were, it had been cleared approximately 0 to 10 inches.
All right. And do you have an end of scene, a day scene observation, Bates stamped 3433?
I don't have.
It says page 22 on the bottom.
Thank you.
There's handwritten Bates stamps, so ours may be different.
Yes, page 22 of my report is what I just
Okay.
testified
All right.
about.
And did you read the last sentence?
The last sentence under my end of day observations?
Yeah.
Yes, that's what I had mentioned about around the tree and tree roots being cleared approximately 0 to 10 inches as determined with the tape measure.
Okay. Now, I believe you previously testified that you took photographs when you arrived at the scene. Is that correct?
Yes, that's correct.
Okay. And when you took photographs in and around the area of the scene in which the remains were moved, did you alter the remains or take anything off the remains that was touching the remains or the vegetation around it, other than to maybe lift something that was hanging over it?
The vegetation around the area was cleared to the point of the vines being cut and tied back, but I do not recall removing any vegetation from actually on top of the skull or on top of any other evidence, again, other than just clearing away vines that was obstructing the view.
All right, and I just need to confirm in terms of the photographs that you took, they would be CSI call numbers, is that correct? Is that how you determined them?
The photographs are entered into our database under call ID numbers. That's correct.
All right. And are you familiar with the call ID number 1932?
I do not have a record of 1932 as a call ID number.
All right. Did you take photographs of the scene after the vegetation had been cleared?
Yes, I did.
Okay. All right. May I have permission to publish this just to the witness?
Which exhibit is it?
This has not been entered in yet as an exhibit.
Okay. You may publish it to the witness.
Request that it be marked for identification so that there is a permanent record of what's being done.
And what would that number be?
Hand it to the clerk. Yes. Speak up a little louder so the clerk can, the court reporter can hear you.
It appears to be, yes.
That appeared to be a photograph
Okay.
that represented the scene after the vegetation had been cleared.
Thank you.
And I'm not really sure how to work this, so, Will, can you?
It's upside down. Flip it over, yeah.
There we go.
Pull it down, son.
See these fitting in between these
Oh, I see. Okay. Great.
Published to the witness, not to the jury.
You want permission to publish to the witness?
You offered any evidence?
Yes, sir.
Any objections from the state?
No, sir.
It will be received in evidence as defense exhibit number. Okay, you may publish it to the jury.
Thank you. And can you identify, please, what that photo?
Okay, it's up. It's about a 4-second delay.
That's right, I forgot. Ms. Welch, can you identify that photograph, please, and advise the ladies and gentlemen of the jury what that represents?
It appears to be the scene after vegetation had been cleared.
Okay. And is that an accurate depiction, in your opinion, of the scene, the area in which the remains were found after the vegetation had been removed?
From what I recall, yes.
Okay. Permission to unpublish, Your Honor?
You may.
Can you tell me, please, in your report, and since our Bates stamp pages appear to be different, if you could look on page 5 of your report, and can you tell me, please, whether or not there's a reference to a log or a tree near the remains and what happened to that log or tree?
Yes. The log was located directly near the skull, which was observed on December 11th, 2008. During the process of clearing and moving vegetation, the log was moved by Chief Medical Legal Investigator Stephen Hansen and my supervisor Susan Mears on scene.
I have a photograph that I would like to, with the court's permission, publish to the witness for identification. And it's 1840-196206.
Okay, has the clerk marked it?
Yes, sir.
Okay, let the clerk mark it.
Thank you. Do you recognize that photograph?
Yes.
Okay. And is that photograph an accurate and true depiction of the scene in which the remains were found on December 11th, 2008?
Yes.
Okay. Your Honor, may I have permission to publish this to the jury?
Any objections? Did being offered into evidence?
The only objection is as far as time when it was taken and what point. I would object to the relevance unless we know at what point in the process this photo was taken.
I'll be glad to clarify that. Can you tell us approximately when this photograph was taken?
I cannot give you an approximate time, but I can tell you that from looking at this photo, this appears to be a photo that I had taken after vegetation had been moved out of the way. In other words, to aid in no longer obstructing the view.
No objection.
When you say
Go ahead. Go ahead.
when you say after vegetation had been moved away, that's hanging vegetation, not anything that's laying on the items themselves. In other words, no leaves were removed or twines that were actually touching the items. Is that correct?
Yes, from what I recall, this photo is just vegetation being moved out of the way to no longer obstruct the view. I do not recall removing vegetation off of the items.
Okay. Your Honor, may I have permission to publish to the jury?
Okay, any objections to coming in evidence?
No, sir, no objection.
Madam Clerk, be admitted into evidence as defense exhibit numbered.
Defense CA will become defense exhibit number 28.
Okay, you may publish 28.
Can't tell if it's up. Okay. Thank you. Your Honor, may I unpublish?
Members of the jury, have you seen it? Okay, you may unpublish.
Thank you. That's all I have of this witness, Your Honor.
Cross-examination.
Let me have those photographs. This is the other one.
Mm-hmm.
May I republish Defendant's Exhibit 27, Your Honor?
You may.
To the jury. Just, can you tell us what portion of the scene, this is, maybe orienting us by some object that was found? I'll zoom out a little bit so we can see the whole thing, if that helps you.
While it does appear to be a photograph of the scene, without going through my CD of photos in the sequence of photos, I can't tell you precisely where in the scene this is located.
So you couldn't like point to a spot and say this is where the skull was, where the you don't know from this photograph.
That's correct.
No further questions, Judge.
Any redirect?
Just very briefly. Ms. Welch, how did you identify the grouping of photographs? Did they have call numbers? How did you do that?
I guess I don't understand the question. I'm sorry.
Okay, you took photographs, and there's a series of photographs that I understand it have CSI call numbers like 1832, which contains a number of photographs, 1840, 1842. What was your identification system for those photographs?
What I did was I took the photographs out on scene, and then they were uploaded into our digital crime scene system. When they are uploaded into that system, the system gives it a call ID number. That way we can go back into the system, or a detective, if needed, can go into the system, put in that call ID number, and pull up the photos that are under that call ID number. So it is not a number that I created, it's a number that the system created.
Okay, and do you have those numbers here today?
Yes, I have the numbers.
Okay. And just for clarification, if I read them to you, would you be able to verify that they are, in fact, the CSI call numbers for the photographs that were taken on December 11th, 2008?
I would be able to tell the number of photographs without actually going through my report and looking at the corresponding number of photographs to the call ID. I wouldn't be able to tell you exactly what day the call ID matched up with.
But you would be able to determine that these were photographs that were taken at some point in time, December 11th through the 14th, approximately?
December 11th through the end of the investigation, I would, yes.
All right. And do you have those call numbers readily available?
Yes, I do.
Okay. Would one be 1838?
I do not have a call ID number of 1838.
Okay. What are the call numbers that you have?
I have call ID numbers 1840, 1842, 1845, 1849, 1893, 1903, 1913, 1919, 1923, 1934, and 2088.
All right. Thank you, Your Honor. That's all I have.
Okay. Any additional questions?
No, sir.
May Ms. Welch be excused?
Yes, Your Honor, subject to recall.
Okay.
Yes, sir. Again.
You may be excused, subject to recall. Thank you, Ms. Welch.
Thank you.
Defense may call their next witness.
Your Honor, the defense would call Dr. Jane Bach.
Okay.
Some exhibits.
Yes, ma'am.
Raise your right hand and answer out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please.
My name is Jane Bock, B-O-C-K.
You may proceed.
Thank you, Your Honor. Dr. Bock, what is your occupation?
I'm a botanist.
All right. And what type of botanist are you?
My specialties are plant ecology, plant anatomy, and forensic botany.
And can you tell us what forensic botany is?
Forensic botany is the applications of plant science to matters of the law.
All right. And can you give us the benefit of your education?
Certainly. I have a bachelor's degree in botany from Duke University in North Carolina, a master's degree in botany from the University of Indiana in Bloomington, and a PhD in botany from the University of California at Berkeley.
All right. And have you had an occasion to teach botany?
Yes, I'm a retired biology professor, and I taught botany and I'm still teaching it a little bit, 40 years.
Can you speak a little closer to the microphone? I think some people may be having problems hearing you.
Yes.
Can you say that again? You taught what?
I've taught botany for 30 or 40 years.
All right. And have you authored any publications in scientific peer-reviewed journals on botany and forensic botanical issues?
Yes, I have about 80 peer-reviewed papers, maybe slightly more by now.
And what does peer review mean?
It means that you send in a manuscript to an head editor, and if they decide it might be of interest to their readers, they send it out to people thought to be expert in the field of the topic of the paper.
Okay, and have you authored any books?
Yes, I've authored 3 books and edited another one.
And what are the topics of those books?
2 are on plant ecology. 1 is on forensic biology and botany. And the 3rd one is on plant ecology.
Plant ecology?
That I edited.
All right. And can you tell me, please, whether or not you've received research support and from what organizations?
During my academic career of about 30 years, I had continuous research support from the National Science Foundation, not all of them at the same time. The National Science Foundation, the National Institutes of Justice, the Charles A. Lindbergh Foundation, the National Park Service, U.S. Forest Service. That's a good sample.
All righty. And what organizations, what professional organizations are you a member in?
I belong to the American Academy of Forensic Sciences. I belong to the International Association of Identification. I belong to the Botanical Society of America, the British Ecological Society, NEC Research International, and a couple others.
All right, and can you tell me whether or not you've given testimony in trial or deposition as an expert in forensic botany?
Yes, I have.
And approximately how many times?
50 plus if you count depositions.
And have you ever given testimony in cases in which you applied your knowledge as a forensic botanist to determine whether or not the remains of an individual had been moved from one location to another?
Yes.
Your Honor, at this time we would like to offer Dr. Bock as an expert in botany and forensic botany.
What says the state?
No objection to her qualification, and if I may have a moment with counsel as the court is announcing her.
Okay. Ladies and gentlemen of the jury, Dr. Bock would be accepted as an expert witness in the area of forensic botany and permitted to render opinions in that area. You may continue.
Thank you, Your Honor. Dr. Bach, what items have you reviewed in preparation for your testimony here today?
I have looked at photographs taken by the medical examiner and photographs taken by the Sheriff's Department crime scene investigation people. And I have visited the discovery scene, and I have read several documents, printed documents concerning the case.
All right. What printed documents have you reviewed?
I reviewed the medical examiner's report. I've reviewed the description of the recovery site as described in Ms. Welsh's materials.
All right. And any reports from anyone else?
Yes, I've read the report of a forensic botanist, David Hall.
All right. At some point in time, Dr. Bach, did you visit the area in which the remains of Kaylee Marie Anthony were found?
Yes.
And when was that?
That was the first day of February.
Of what year?
2009.
All right. And can you tell me, please, whether or not you took any photographs?
I didn't take the photographs, but with me was Patrick McKenna, a photographer, and he took photographs of me at the crime scene and of the, not crime scene, recovery site and my work there.
Your Honor, may I have permission to show the witness an enlarged photograph that was taken at the time in which she was visiting the scene?
You may.
Are you familiar with this photograph?
Yes, I am.
All right. And how are you familiar with this photograph?
This is one of the pictures that Patrick McKenna took when I was at the recovery scene.
And can you tell me whether or not it accurately reflects your visit on February the 1st, 2009 to the area in which the remains were found?
Yes, it does.
Your Honor, may I have permission to publish this video?
Have we got an ID number on it?
No, sir, we do not. Oh, I'm sorry. Oh, it is. Okay.
If it's being moved to evidence, I have no objection.
It is 2008. Oh, CE. I apologize. It's CE.
You offered it in evidence?
Yes, sir, I am.
What says the state? Any objections?
No, sir.
If we received an evidence as defense exhibit number,
Number 29.
you may publish.
Thank you, Your Honor.
You know, I might want to suggest we might want to get a lavalier mic for Ms. Sims. She's very soft-spoken. I'm not sure that people are going to be able to hear her without.
Yes.
I can be louder.
Okay.
Well, it's a lot easier with a lavalier mic, so.
Dr. Bach, is this? Okay. Dr. Bach, can you describe what is here, this area on the ground? What would you call this?
I'd call that leaf litter.
All right. Thank you. Your Honor, may I have permission to move the photograph down?
Yes.
Thank you. Can you tell the ladies and gentlemen of the jury what leaf litter is?
It's a general term used for leaves that fall off vegetation overarching the area where the litter accumulates. Mostly, in this case, it was leaves, but also pieces of stems can fall off of trees and needles from evergreen plants.
All right, Dr. Bach, let me ask you, after having read the reports and the photographs that you mentioned, and having visited the scene, the area, some 7 weeks and 1 day later, can you tell me whether or not you have formed an opinion as to the shortest period of time that the remains of Kaylee Marie Anthony could have been at the scene in which they were found?
Yes, 2 weeks, approximately 2 weeks.
And can you tell us when the remains were placed there?
No.
And what is the basis for your opinion that it is possible that they were placed there approximately 2 weeks prior to their discovery?
Because of the pattern of the leaf litter.
The pattern of the leaf litter?
Yes.
And with regard to the vegetation that was found in the car that was driven by Casey Marie Anthony, do you have an opinion with regard to the vegetation that was found in that car versus the vegetation at the scene?
It isn't in agreement with the vegetation.
I don't believe it's been established that the witness has ever looked at the vegetation. That the witness has ever looked at the vegetation from the car, or what her basis of knowledge of that is.
I'll back up and clarify.
Sustain, establish a foundation.
Dr. Bach, did you review a report from Dr. David Hall dated October 31st, 2008?
I did.
Okay. And can you tell me whether or not Dr. Hall set forth items that were found in or under the vehicle driven by Ms. Anthony?
He described vegetation and vegetation fragments associated with the vehicle.
All right. And with regard to that vegetation, what kind of vegetation was found?
Bits of leaves, for the most part.
From what?
Especially from a camphor tree.
All right. And can you tell me, please, whether or not there is a camphor tree at the scene in which the remains of Kaylee Marie Anthony were found?
There is not one.
Did you review a report authored by Dr. Hall dated February the 9th, 2009?
Yes.
All right. Let me ask you about that report. Does the field of botany...
Objection to counsel eliciting comments on someone else's report.
Overrule at this point. I don't know what the question is.
Does the field of botany train botanists to estimate how long a root has been alive if they don't know the root solely by measuring the diameter of the root?
Objection. May we approach?
You may.
Dr. Hall.
Just a second. Okay, objection sustained. You may continue.
Thank you, Your Honor. Dr. Hall, when you look at the photographs,
I'm Dr. Bach.
I'm sorry, Dr. Bach. It's been a long day already. Dr. Bach, when you look at photographs that were taken in this case, can you tell us by looking at the photographs how old the roots and the plants are? Just by looking at the photographs?
No.
Why?
Because I don't know what plant those roots came from, and size and growth rates and all those things.
Can you get closer to the mic? I'm sorry.
Size and growth rates are characteristic of an individual plant, and they differ greatly among plants.
What kinds of things cause them to grow at different rates?
It may be the mineral nature of the soil, the presence or absence of lots of calcium, nitrogen, water, other plant roots being in the area, water, lots of water or a little bit of water, and so on. In other words, environmental factors.
All right, and if you were to attempt to determine how fast a root grew, what would that require in your field? What would you need to do?
First, you would need to know what plant it came from, and then you would need to do time-spaced observations on growth rates.
And when you say time-spaced observations, can you break that down for me?
Sorry.
And get closer to the mic. I'm going to be on you for that.
You would keep track of how the root elongated, at what rate it elongated, and what size changes occurred.
How would you keep track of that?
With a ruler, with a notebook, with a camera, with whatever you had at hand to help you. Or you could do it in a laboratory.
In layman's terms, you would watch it grow and measure it as it grew over time? Is that what you're saying?
Yes.
Okay.
Yes.
Thank you, Your Honor. That's all I have.
Okay. Cross-examination.
Thank you, sir. Good morning, Bob.
Hi, Mr. Ashton.
How are you?
I'm well, sir.
You're from Colorado, is that correct?
That's right.
And most of your work has been in that area of the country, that sort of middle area of the country. Is that not correct?
No, that's not correct.
How much time have you spent actually working in Florida as a botanist?
It was the site of my PhD thesis work. And since then, I have had individual research projects in Florida and hope to have more in the not-too-distant future.
And when your PhD is from what institution?
University of California at Berkeley.
And you said your PhD thesis and when was that, if you don't mind me asking?
No, I don't mind. I got my PhD in 1966.
And what was your actual work in Florida in the 60s for your PhD?
Moving up and down the state, looking at the distribution of water hyacinths in freshwater bodies in this state and also in semi-marine areas, estuaries.
All right. And other than that, what other projects have you worked in botany since 1966 that have brought you to Florida to actually work in Florida?
I studied the food habits of the tortoise, right, which is an endangered species and is a vegetarian.
And when was that?
That was from about 1980 off and on through 1990.
And how did that work actually bring you to Florida? In other words, would you come for a few days? Did you live here then? Tell us a little about that Florida experience.
My parents lived here. I came to see them. I also had some research support about tortoises in general, and I use some of that report as well.
Right. Any other involvements you've had in studying botany in Florida?
Yes, I have. I was friends with the person who wrote the first Flora of Florida. It's the late Robert Long, and I was very interested in the progress on his work. Subsequently, I've used field guides to Florida plants in order to become familiar with the thousands of plant species, native and non-native, that exist here, to further my botanical knowledge.
Was that review recently in preparation for this case, or just in general? In general. And it continues to now. And any other involvements with studying botany in Florida, other than I believe you told me about 3 projects? No. All right. Now, most of your work has been in studying grasslands and grasses. Isn't that correct? Part of my work, and a big piece of it, is concerned with grasslands, here and in South America, and yes, here and in South America. And you would agree that different areas of the country have unique botanical ecologies that differ? Yes. Correct? Now, you visited the area where this body was found, correct, as you said? I did. And you also reviewed photographs of, a large number of photographs of the scene, both in its pristine form and then at various levels of exploration. Would that be correct? And you would agree that this area, based on the botanical specimens seen, is basically sort of a swampy area, an area that's frequently wet. How would you describe it? It has been characterized in the ecological classifications as a swamp hardwood. Swamp hardwood. But that's an interesting term. Part of the plants that are common there are upland plants, not swamp plants, so they aren't wet all the time or frequently. Others are. All right, so you would characterize this as an area that wouldn't necessarily be underwater all the time, no, but would frequently be underwater. Frequent. I don't know what you mean by frequent. Well, the plants that you saw there are many of them are species that require a great deal of water. Yes, at certain times of the year. So you agree that the general character of the area is an area that is at least, we'll say, occasionally underwater? Yes. Okay. Or wet. Or wet. Now, your statements to counsel that you believe this body could have been there for as little as 2 weeks, you quoted the leaf litter, but is that opinion based upon looking at all of the botanical evidence in the case? Yes, it is. Yes. So you viewed the roots that are growing through the hair mass, and is it your opinion that those roots could have grown there in just 2 weeks in December? Could have accumulated there in 2 weeks, yes. Well, is there a difference between grown there and accumulated there? Yes. Okay. My question was, could they have grown there in 2 weeks? Yes. And the roots which are growing through the laundry bag, you recall seeing photographs of a canvas sort of laundry bag with roots growing actually into the fabric. You recall those? Yes. Okay. And is it your opinion that could have occurred in only 2 weeks in December? Yes. And the roots that are growing in the bones, did you see the photographs of roots actually growing into the bones in this case? Did you see those? I saw the photographs. I also saw the bones, some of them. And are you presenting the opinion that growth into the bone could have occurred in 2 weeks in December?
I suspect so, but I'm no expert on bones, and I'm not qualified to comment about osteology. But based upon what I know about the ability of roots to penetrate substances, yes.
But you, I believe, have, and I appreciate candidly admitted that you have never dealt with a decomposing skeleton where you had root growth in the skeleton. You've never had that experience, is that correct?
Yes.
Now, sorry, go ahead.
I have in skeletons that had been in place for several years.
So you say you have dealt with?
I have looked at that evidence. And so sometimes yes and no is not so easy.
Okay. Well, let me just put it to you this way. Have you had the occasion to examine a skeleton where plant or root had actually grown into the skeleton?
Yes.
Okay. Let me direct counsel and the witness's attention. Do you recall giving your deposition on February the 12th of 2011?
Oh, yes.
Okay. For counsel's benefit, this is page 64 going to page 65. Do you recall the following question being asked? Okay, well, let me put it to you this way. Have you ever had occasion to examine a skeleton where plants or roots had actually grown in the skeleton? You said, this would be page 64, line 24. You answered no. However, I've taught classes where I've done experiments getting roots to penetrate heavy, thick articles. I asked bones, and you said, I'm trying to think because they're just amazing. Clay, I don't think I ever used bones. No bones. You said, doesn't sound like me.
Not in teaching. However, I belonged to an organization and was present at a crime scene where there were forensic anthropologists, forensic archaeologists, etc., MDs, and I observed in this perhaps 10-year-old skeleton, by that I mean it had been there 10 years, I did see roots, and so I should have qualified what I said, but I didn't even think about that when you asked me that question.
So when I asked the question, that incident didn't occur to you, but it's occurred to you more recently. Is that correct?
I just calmed down and thought of it.
Okay. But at any rate, you would agree that your experience with roots grown in bones is extremely limited.
Yes.
As you said. Now, in the photographs that you viewed, you would agree that there is leaf litter built up on the skull for at least sort of to the area of the lower portion of the eyes, correct?
I'm not sure what you're...
Did you see the photographs of the skull as it was found in its pristine form before any leaves or anything had been removed? Yes,
Perhaps. I don't know when individual leaves were removed.
If I may have just a moment, Your Honor. Make sure I've got the evidence number. Yes, Your Honor, I'd like to show, and Mr. Perez, if you could pull up photograph in evidence 211. And may I publish to the witness and the jury?
Yes, you may.
Now, are you familiar with this photograph?
Yes.
Do you agree that this photograph shows that the skull is buried in leaf litter up to about the level of, say, the ear or the nose area?
I see one leaf on top of the bones.
Well, I wasn't asking about the leaf on top of the skull. I have a telestrator here, so I'll mark what I mean. Around this area, you can see that leaf litter has collected around the skull up to about the area above the jaw, sort of covering the opening of the nose. That's how high the leaf litter is, isn't it?
I suppose that's all leaf litter, but it may also be humus.
Well, whatever it is, it clearly has collected to a level that rises to approximately above the jawline and to the level of the nose. Whatever it is, it's collected to that height. Wouldn't you agree?
Okay.
And is it your testimony that that amount of leaf litter can collect and pile up in that form in just 2 weeks?
There are other considerations about this picture.
Well, I would just, if you would direct your consideration to my question, I would appreciate it.
Yes.
I apologize, I just wanted to make sure that the witness had finished her answer.
Ma'am, did you finish your answer?
Yes.
Okay, thank you.
All right, so let's also go to now State's Exhibit 213 in evidence, if I may publish that as well.
You may.
Thank you. This is, do you recognize this as a photograph of the skull when it is returned to the medical examiner's office with the leaf litter around it collected with it?
Yes.
And would you agree that this reflects leaves of widely varying degrees of decomposition?
Yes.
Some of them retain are still green. Some of them are sort of yellow, and some of them are brown, and some of them are completely gray. Do you recognize that?
Yes.
Is that a reflection of a variation in decomposition level?
It also is a reflection of when the leaves fell from trees.
All right.
Some fall from trees when they have no chlorophyll left. Others are blown in to a place. Others shed their leaves when they're still bright green and the chlorophyll hasn't retreated.
But is it your testimony that all of these varying levels of decomposition in the leaves immediately around the skull could occur in just 2 weeks in December?
Are you talking about the left side of the skull or the right side of the
Either
skull?
side.
Because I don't understand exactly. I did read. I don't understand exactly how this collection was made.
If I might, for purposes of my question, if you would accept the following hypothetical, that the medical examiner investigator put his hands approximately 6 to 8 inches on either side of the skull, reached into the ground to dirt level, and attempted to the best of his ability to lift the entire leaf litter both around and under the skull intact to the best of his ability.
And undoubtedly collected things and must have moved some toward the skull.
I think it would be hard not to. But do you recognize in this photograph a widely varying group of decomposition rates? Or that these leaves have fallen at all different times and at various levels of decomposition, correct?
Yes, I imagine some were.
And some of these leaves clearly have been off the trees for a lot longer than 2 weeks, haven't they?
And lying under other things, perhaps.
My point being, if these leaves are in fact the level that has fallen since the skull has been there, then clearly the skull has been there for a lot longer than 2 weeks. Wouldn't you agree?
Given your hypothesis that it had...
Go ahead.
Given your hypothesis that it had lain there undisturbed all that time, the answer would be yes.
Then what is it that you're basing your 2-week estimate on, if not the very leaf litter that we've just discussed?
The fact that the litter in the picture that was displayed up there,
Which picture?
the big cardboard picture.
Oh, the picture that taken when you were there.
Yes.
Okay, in February. All right.
All the leaf litter that was there was accumulated on ground that was scraped bare by the 15th of December.
Are you familiar with leaf fall rates for trees indigenous to Florida? In other words, what times of year they've dropped their leaves, at what rate? Are you familiar with any of that information?
Yes.
If I may... I believe... Is this the one you're referring to, Defense Exhibit 29?
Yes.
All right. So what you're saying is that because there are the amount of leaves on the ground here, which occurred in approximately 6 weeks, but the leaf litter isn't covering the ground, is it?
In some places it is, in some places it isn't.
Where do you... May I pursue this?
May.
Do I need a lavalier, Judge? Can anybody hear anything?
It would help tremendously if you did have one.
Can you hear me now? I turned it on. Oh, he's on now. Thank you. We got it. May I have the witness step down? That might actually be easier. You would step down, Doctor?
Yes.
Now, Doctor, and just sort of step to the side there so the jurors can see, you would agree that largely this area, most of what you see is bare ground or bare roots, not covered by leaves. Is that, like, this area here is bare, this appears to be some sort of root here. What area do you feel is covered with leaves? You're talking about the area to the left of the photograph. Now, is it your testimony that the amount of leaf litter seen in this photograph is greater than the amount of leaf litter built up around the skull?
It could be the same as.
Okay, I'm sorry. We probably need a a lavalier for her too. I apologize.
I can use my professorial voice.
Well,
It could be the same as.
is that good enough for everybody? Okay. Professorial voice will be fine then. All right. But so your position is that this leaf litter we see here, even the greatest accumulation, is equivalent to the leaf litter going up approximately to the victim's jaw line or nose that we saw in the photographs. Your opinion is those are the same.
The leaf litter that was obvious in that picture certainly is equivalent to that.
Did you measure the leaf litter in any of these areas of accumulation?
No.
Now,
Did anyone else do that?
neat thing about this is you don't get to ask me questions. But that's okay. That's okay. Now, I'm sorry, Tim. Now, in this condition, you would agree that this area has been stripped bare not only of ground vegetation, but of overhanging vines, correct?
Yes, according to what I read, but I wasn't there then.
Well, you've seen the photographs.
I have.
And you would agree that the photographs show this was a densely overgrown area with a number of overhead vines, etc. Very dense.
Yes.
Right. Now, this configuration would permit leaves to blow and build up in particular areas, correct?
Sure.
That might not necessarily be the same in the scene photos where you had heavy vegetation that would have prevented leaves from blowing and collecting in certain areas. Wouldn't you agree?
No.
In the area where the body was found, when it was pristine, is it your testimony that there was nothing impeding the blowing of leaves through the vines and the overgrowth and all the other stuff?
There are complications to things flowing freely here and there as well.
Why are there no leaf fall on the right side of the photograph as opposed to the left side of the photograph? Can you explain that to the jury?
Excuse me, let me interpose that objection, Your Honor, because I think it misstates the evidence.
Judge, the photograph speaks for itself.
Overruled.
You would agree that this side of the photograph has considerably less leaf fall. That is, the right side of the photograph, you're facing it, is considerably less than the left. You would agree with that?
Yes, at that moment in time, it does indeed.
So, I guess my question is, why is that?
I can think of several possible reasons.
Okay, go ahead.
People trampling around. This was a frequently visited spot after the recovery became public knowledge. And that's one possible explanation.
What other?
Wind action is another. Animals is another. And the nature of the trees themselves, just as root growth depends upon the kind of plant it was, similarly, leaf fall rates depend on the kind of plant it was. This flora is not, it's semi-tropic. Some of those plants are evergreen and keep their leaves all year round, but that's deceptive. They shed leaves all the time. They drop pine needles. The other evergreen trees are constantly shedding a few leaves at a time. Other plants in this forest, certain species, just drop leaves in the fall.
Now, it's important in comparing this photograph to the photographs of where the skull was found to compare apples to apples, to compare the same spot to the same spot.
Yes.
Where on this photograph was the skull?
To the best of my understanding, because I was not there with someone who absolutely knew it was right in here.
Well, you don't really know.
No, but I was told that this particular tree had significance.
So you were told by somebody that wasn't actually there when the skull was removed by Mr. McKenna, correct?
Mr. McKenna had visited this site several times before I did, the week before I was there, with people who seemed, who should have been informed, and I suspect were informed.
Okay. Who was that?
Linda Bodden.
Was it some defense attorneys in the case? Without saying names, is that who you're talking about?
Yes, and other expert witnesses too,
Okay.
forensic scientists.
Now, so your opinion, your impression was it was exactly where?
It was in this area.
Somewhere in this area here.
Yes.
Okay. No further questions. Sorry, have a seat. Thank you very much. No further questions on that issue. I just have a seat. The bottom line of Dr. Bach is you are not prepared at this point to render any opinion to this jury about when Kaylee Marie's body was left at that scene. You can't render any opinion. Is that correct?
I thought I had rendered one.
Well, so let me ask you this question. Are you prepared to render an opinion in this case as to when the remains of Kaylee Anthony were placed at the location they were found?
No.
Okay, so you are not prepared to render an opinion as to when they were placed?
I did render an opinion.
Now you've lost me. Are you rendering an opinion as to when you think these remains were left there?
A couple of weeks before.
Do you recall me taking your deposition again on February the 12th of 2011, page 68 for counsel line 16? I asked you, okay, are you prepared to render an opinion in this case as to when the remains of Kaylee Anthony were placed at that location they were found? You answered no.
I don't remember what went on before that and after that with your questioning, but if I said it, I meant it, however it was tendered.
May I approach the witness? Just want to let you take a look at it. If you want to read the context, feel free.
We were discussing Greeley, Colorado at the time, but I know why I said that.
Okay. Did you explain to the jury why you answered no in February and apparently yes today?
I don't know exactly when it was placed there. My best guess is what I have presented today.
Well, now, on direct examination, you said that, in your opinion, it was a minimum of 2 weeks. Are you now indicating that it was a maximum of 2 weeks also?
No.
So you're not of the opinion that the body had only been there for 2 weeks, correct?
It's possible.
Okay. It's also possible it was there for a great deal longer than 2 weeks.
Yes.
No further questions. May I approach to retrieve the deposition?
You may.
Oh.
Redirect.
Dr. Bach, you were asked questions about how long you'd studied plants in Florida, And then I think you mentioned that it was a semi-tropical area, the area in which you viewed where the remains had been found. Is that correct?
Yes.
All right. Let's be more specific. How many years have you studied plants, vegetation, and botany in semi-tropical areas?
30 years.
Okay. And how many years have you taught plants and botany and roots, growth, etc., in areas growing in semi-tropical regions similar to the areas in which the remains were found?
Throughout my time as a professor, 31 years, at least.
All right. And if a bone fragment has a hole in it, can you tell me whether or not a root can grow in the hole?
No.
A root fragment, if there's well, let me put it another way. If there's an opening, whether it's a bag or any substance, is it possible for a root to grow into that opening?
Depending upon what kind of root it is.
Okay. You were asked about leaf litter. Did you see the log or the tree that was near the remains?
Yes, I did.
And did you see fallen leaf litter on that log?
No.
And what is the significance to you of that, if any?
It inspired me to look at that log.
Why?
Because I was curious about whether it had been turned over, whether it had laid in that position for a long time.
And was there any documentation in any of the material that you reviewed that weighed the log or identified how long it had been there or determined what specific vegetation was around it, was under it, was on the side of it?
In Officer Welsh's summary reports, she discussed that it took 2 people to move it. So I suppose it was heavy.
Was there an identification of the plant material under the log?
No.
Or to the side of the log? What information could that have given you?
Objection calls for speculation and relevance and exceeds the scope of cross.
Overruled.
I believe it could have indicated how long the log, the tree, had been in that position, had it been moved, how far along decay was, and something more about other plants in the area, perhaps.
All right, and you were asked about humus and leaf litter, and I'm about to, if, with the court's permission, approach the pad and make a drawing.
Okay.
And ask the witness to stand down, if possible.
You may, Doctor.
Do I need the lavalier? Could you draw humus for us, Dr. Bach, and then draw leaf litter on top of that? And could you use your professorial voice?
Yes.
Soil is made up of a series of layers, and the top layer is called the humus layer. It's the layer usually that has the most organic matter in it, broken down plant parts and animal parts, insects, bacteria, and so on. And as you move down in the soil, it becomes less and less organic. That is, it becomes more and more pure rock and sand. So this line is the top of the soil. The humus layer is this top layer. And on top of this that sketch represents leaf fall, but it could be other things as well. It could be twigs of various sorts. And in this case, remnants of roots of things sometimes appeared right on top of the humus area. Those eventually, through the process of decay, will be incorporated into the humus.
Okay, thank you. And let me ask you a question. On the date in which the photographs that you observed that you understood to have been taken on or around the time in which the remains were found, what were the conditions? Was it wet?
Your Honor, could I object and ask you to identify which photograph by evidence number?
Well, the photographs that you were shown.
Your Honor,
Sustained, need to identify it by the evidence number so the record will be clear.
All right, I'll just rephrase the question, Your Honor. When you looked at the photographs which had the remains in place prior to their being moved, can you tell me, please, what the conditions or moisture appeared to be during that time?
Same objection, Your Honor. We need to reference a photograph so we know what the doctor is.
I'll move forward. I'll withdraw it and move forward.
Okay. Question withdrawn.
All right. Doctor, if you have an item and you place it on leaf litter and the area is very wet and the humus is very wet, can that item sink?
Of course.
Thank you.
You may resume your seat, Doctor.
Thank you.
Your Honor, that's all I have as witness at this time.
Any recross?
Could I ask counsel to move the easel back if they're done with it? Thank you. Doctor, is it your testimony that the skull in this case sank into leaf litter or humus or anything like that?
It could have. I don't know.
Or it could not have.
Or it could not. Or it could have been pushed. I don't know.
Or it could have been laying on top of the leaf litter, and the leaf litter, by a natural process over several months, collected around it. That is also a possible explanation.
Yes.
For it. Were you aware that one of the bones from this skeleton was buried in 4 inches of muck?
No.
Or humus? If you had that piece of information, that by operation of time or operation of water movement, that one of the bones was buried 4 inches into what is described as muck, would that not tend to indicate that this skull had been there for a great deal longer than 2 weeks?
The skull was in...
I'm sorry, a hip bone, was buried in 4 inches of what is referred to as muck, which I assume is wet. I assume you would call wet humus. Wouldn't that indicate pretty conclusively that this skull had been there a whole lot longer than 2 weeks?
Or a dog buried it?
I'm sorry, a dog buried it.
They do, as do coyotes. I don't know if you have those here.
No, we're not blessed with coyotes, but we have a lot of other things. Thank you very much, Doctor.
Okay, may the doctor be excused?
Yes, sir.
Thank you, Dr. Bach. You may be excused. Okay, ladies and gentlemen of the jury, we're going to take a recess at this time. Special one? Okay. All right, we'll take a recess. I'm going to give the jury 20 minutes, but I'm going to give the attorneys 15 minutes. There's a matter we need to take up before they come back in here. Jury will be in recess for 20 minutes. You will be in recess for 15. Okay, court will come to order. Mr. Bias, who is the defense's next witness.
Richard Eichenbaum.
Okay. I have reviewed the requested instruction that the state has proposed, and I've reviewed the instruction that the defense has proposed. Now, did Dr. Eichenbaum provide a partial report?
No, Your Honor. He provided an affidavit, and he, in deposition, referred to it by that term as an affidavit. It does not. I provided the court with a copy of it the other day. And,
well, this is what I'm looking at. It says affidavit R. Eichenbaum dated January 21st, 2011. Is this what he provided?
Yes, Your Honor, that's the item that was provided to defense counsel.
This is the instruction I propose to give. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reason for those opinions or conclusion, and 3, any data or other information considered by the witness informing their opinion or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. Mr. Bias?
Yes, sir. We maintain our objections since I have withdrawn the areas that were previously at issue. We would just, for the record, object.
Okay. Before I do that, I need to have the witness come in, and I need to make an inquiry of the witness, and then I need, before I formally impose the sanction, I need to make a 3-prong finding for purposes of the record. So let's have the witness come in. I have a few questions I need to ask him. I will file, this first item is the defense's proposed instruction, if I was going to give an instruction. The second item is the state's handwritten requested instruction.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
My name is Richard Eichenbaum, E-I-K-E-L-E-N-B-O-O-M, Eichenbaum.
Doctor, I'm Belvin Perry. I'm the presiding judge in this case. When were you first retained by the defense?
The first investigation was, or the first request, official request, for the case was when we had to look over the evidence.
And when was that, sir?
That was on 13 July 2010. And of course, it was a couple of days before that.
July 2010.
Yes.
Sir, were you ever informed that you were required to produce a report outlining the opinions that you rendered in this case as a result of your examination of the evidence?
Except for the affidavit, I was not told that I had to render opinions or write another report.
Sir, were you ever informed of the following? Where expert witnesses have not prepared reports of examinations or tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in form of a written pleading. 1, the expert's curriculum vitae or qualifications of the expert. 2, the expert's field of expertise or medical specialty. 3, a statement of the specific subjects upon which the expert will testify and offer opinions. 4, the substance of the facts which the expert is expected to testify. And 5, a summary of the expert's opinion and grounds for each opinion. Were you ever informed of that order of the court?
No, I don't recall that order.
Okay. I take it, sir, that you do not live in the continental United States?
Well, actually, since February, we're living in Conifer. But before that, we were living in the Netherlands.
Okay. How were you communicating with the defense? Was it by phone, email, or by what other means?
By phone, email, and Skype.
Okay. Were you ever requested or asked between December 2010 and May 1st of 2011 to reduce your opinions and findings in writing in a report format as I've just outlined?
Sorry, reduce? You mean to write a report?
To write a report in the format that I've just outlined, sir.
No, I don't recall that.
Okay. Who was the principal person that you communicated with for the defense? Who were you getting your instructions from?
Mr. Baez. And we also had communication with Michelle.
Okay. Now, from May of 2011 up until today's date, were you ever asked to reduce your report in the written format that I've just outlined, which would include all of your opinions that you were asked to produce?
Last Saturday, I talked with Mr. Baez, and then after we went to the district attorney's office to do the deposition where we were refused, I was requested that I would write a report. So last Saturday night, we wrote a short report.
Between December 1st in the year 2010 up until May 1st, 2011, how many times have you communicated with members of the defense team?
Well, I'm not completely sure about that. I know we had communication short before we had to do the inspection of the evidence, and short after, and then for a long time I didn't hear anything anymore. So we more or less lost contact and lost track of the case.
From December 1st, 2010 up until May 1st, 2011, were you readily available to be contacted by the defense team via email, telephone, or Skype?
Yes, the defense could reach us if they want, yes.
You didn't disappear during that time period, did you, sir?
No.
Okay. Either the state or the defense want to ask any questions along those lines that I've just asked.
Yes, sir.
You may proceed.
Mr. Eichenbohm, is this the first time anyone has ordered you to write a report on a case?
To write a report on a case?
No, not on a case, that had certain parameters, like this one.
No, in the Dutch courts, yeah, you sometimes get a request, and that's by an investigative judge, and they can order you to investigate certain evidence or certain reports, or and write an opinion about these items.
And that would be based on things you've done, correct? Like run certain samples of DNA, inspected certain pieces of evidence?
Can be both. Can be on investigations which we have performed, but can also be on investigations of other laboratories, and then they want a second opinion about the methods used or conclusions drawn in those reports.
Okay. And the contact with your company back in January of 2011, that was done through your wife and Miss Medina, was it not?
Yes.
It wasn't
correct.
Directly with you?
No.
Okay. And in fact, what occurred and how this order was, the information got back to you came originally from Miss Medina to your wife, and from your wife to you.
That's correct.
Objection assumes effect, not an evidence that the information about the order ever got to the witness. He's indicated it didn't.
I permit him to go ahead. Objection overruled.
Okay. Now, what you ended up doing is based on what your wife ended up telling you, correct?
Yes. You're talking about a very short affidavit.
Yes, the affidavit. Yes. Okay. And what you in turn ended up doing was filling out an affidavit of all the work that you had done up until this point, correct?
Yes, this is more or less about the evidence viewing.
Which was, you wanted to inspect a piece of evidence for your own testing, but it was denied, correct? Yes. And then also that you had actually gone and done an inspection of the evidence, correct? And took photographs.
That's correct.
Were you ever told in any way, shape, or form to narrow your report or to exclude things from your report?
No.
Okay. And the report or affidavit that you ended up submitting was based on what you thought was required of us?
Yes.
And you never spoke directly with Ms. Medina about what the court has actually ordered?
No.
That conversation actually took place with your wife and Ms. Medina, correct?
That's correct.
And then later on spoken to you, correct?
That's correct.
Do you recall exactly what your wife told you was required by the court? If you can remember.
No, I don't recall that.
Do you remember that conversation at all, only that maybe it happened?
No, I don't remember the conversation at all. And the affidavit, I remember something about the affidavit, but we were very busy in that time. We were in the transfer time that we transferred from the Holland to the United States. So I didn't think much about this affidavit.
And the questions and the opinions that you raised and formulated on Saturday, they were first broached on Saturday, correct?
Yeah, when we were talking about the case on Saturday afternoon after the court session, then the idea came up to write a report or to form ideas about what topics we were talking about.
And these are not opinions that you held before and had discussed with us previously, and we determined that you were going to testify about these opinions prior to Saturday, and you just didn't not include them in your report, correct?
That's correct. On Friday I made a PowerPoint presentation, and just an average presentation for explaining contact DNA.
And Friday's PowerPoint presentation was just a general explanation of touch DNA and nothing more.
Yeah, and how PCR works.
They weren't specific as to any of the issues that were raised in this case, only an attempt to explain touch DNA.
Yes.
Okay. And upon our conversation on Saturday, you were then immediately asked if you would consider taking a deposition at the state attorney's office to now discuss these new opinions.
Yes, so during the lunch, we discussed the topics, and then about which I might be allowed to talk during court, and then we had an appointment with the district attorney's office to do deposit.
Okay. And what happened when you showed up at the state attorney's office?
We were refused entrance.
By who?
By the district attorney.
Who? Is he sitting here?
Yes.
I'll stipulate it was me.
Okay.
That'll help.
And what exactly did he say?
I don't recall exactly what he said, but as I understand it, I was at least not going to do a deposition.
Was he polite?
That sounded kind of rude.
Okay. And after that occurred, were you then instructed by Ms. Medina to immediately do a report?
Yes.
And you did that?
Yes.
And then you emailed that to me Saturday night?
That's correct.
Okay. I have no further questions.
Mr. Ashton, any questions?
May I just do it from here, Your Honor?
You may.
Is there any opinion that you have expressed in your Saturday afternoon report that you could not have developed 4 months ago through the same conversation with Mr. Baez?
Well, it depends on the information which was available at that time, but like DNA reports, that probably could have been, if asked, I could have written a report about that.
Did he give you any new information during, and you spoke at lunch on Saturday?
Yes.
Correct? Did he give you any new information during lunch on Saturday that you had not been provided with before?
Well, for me it was new information because I didn't follow the case. So the case, when we left, we got a subpoena a week ago, or it's almost 2 weeks ago now. So the case for me was not really clear, and I know, of course, about the case, but I really didn't follow it. So for me, maybe the information was there, but for me the information was not clear, and it was not clear which direction everything was going. So I needed that guidance during the lunch.
I understand you may have gotten new information about what Mr. Baez was interested in, but did he give you any new reports, any new factual information that you didn't have already?
I got, I think that was during Friday and Saturday. We got new information, so about crime scene pictures and some extra reports.
What new information?
Reports from the FBI and some extra pictures.
So you hadn't had the FBI reports before Friday?
Not all of them. No.
What new ones were you given? What new FBI reports were you given on Friday?
Oh, I just, actually I got the whole folder. So.
Well, Can you give any more guidance on what you had already and what you got that was new?
I've seen reports before. I think that was during the investigation of the evidence. So I form an opinion about the case, and I know something about what was already then. And during last week, I requested for more information, digital, and I got all the reports, which were then, that's a lot of reports, of course.
And you made that request after you got the subpoena and realized that they were actually going to want you to testify?
Yes.
No further questions.
Okay. Pursuant to Richardson versus State 246 7 seconds 771, a 1971 decision of the Florida Supreme Court, as amplified in McDuffie versus State 977 second 312, a 2007 decision of the Florida Supreme Court. The court will make the following finding of fact. 1, whether the discovery violation was willful or whether or not it was inadvertent. On December 10th, 2010, the court entered an order. The order was entitled Order Granting State's Motion for Clarification / to compel compliance with order for additional discovery. On December 1st, 2010, the state filed a motion to clarify. At a subsequent hearing, it was determined that there was some dispute concerning a prior order that the court had entered in the intent of certain language. The exact language of that court order at the time provided as follows. The defendant shall also provide to the state a list of the defendant's experts that shall include the subject matter as to what the expert would testify to and the area of expertise for each expert. The court goes on to say there was some debate about the word subject matter rather than substance. The court said while the order included the term subject matter rather than substance, the court finds that the list provided by the defense does not comply with the intent of the order or the intent of the court as expressed in its November 29, 2010 hearing. In order to clarify this issue, the court went on to order the following. Where experts have not prepared reports of examination or tests, both the state and the defense are required to provide the following information, which I have previously outlined. The court at that time thought that the matter was clear. In January, the court was back again to deal with this issue again. Going back to the December 10th order of 2010, the court specifically provided, with respect to all other experts, this information is to be provided by 3 p.m. on Thursday, December 23rd, 2010. There were some different deadlines with respect to Dr. Fairgrave and Dr. Bach. That information was to be provided by December 14th, 2010. Again, we had the same problem again, and the court again specified what information and reaffirmed its prior order and assessed sanctions. The obligation are for the attorneys to see that their witnesses comply with the orders of the courts. It is the attorney's job, be it the assistant state attorneys or defense counsel, to make sure that their expert witnesses comply with the order of the court. The court will find that this violation is not inadvertent, that it should have been clearly communicated to the expert, and that the expert should have been required to comply, and the expert was not. Therefore, the court finds that the discovery violation was willful and not inadvertent. The next issue is whether or not it was trivial or substantial. DNA, even though the advent of DNA evidence has been around for a number of years, certain opinions that will be expressed by this witness as a result of the deposition, which is now on file, cannot be viewed as trivial when we start talking about rendering opinions with the of analyzing decomposition fluid in a trunk. So the court finds that it is not trivial but substantial. The next issue is whether or not it had a prejudicial effect on the opposing party in the preparation of their particular case. The court has delayed the testimony of this witness in order to give the state of Florida an opportunity to take this witness's deposition. If the witness had authored a report, put his opinions, the basis for his opinions, and the data which he relied upon with those opinions, then this court would not have given the state an opportunity to take his deposition, because they chose not to do it. If those items would have been in his reports, then the state would not have had the opportunity. The question comes in as to whether or not I need to totally exclude his opinion about the possibility of a DNA analysis which may have some Frye implications, and this court cannot, in this short period of time, make that particular determination. All of the cases indicate that the exclusion totally of testimony is an extreme remedy to be utilized in rare circumstances. The court has decided to do the following. At this juncture in time, the court will not permit the witness to testify on this particular issue dealing with the possibility of a DNA analysis on the decomposition of fluid in the trunk of the car. The court will give the defense until next week by Saturday to file whatever potential motion it wants to lay out for a Frye hearing, and the court then on Wednesday evening or Thursday evening, at the conclusion of the day's testimony, after a 1 hour break to give the attorneys an opportunity to get something to eat, then we will come back and conduct whatever Frye hearing we would need to see whether or not this testimony does meet FRI, or whether or not there is even a FI issue involved in that particular testimony. That should give each side ample opportunity to do what they need to do, and it is a remedy short of exclusion, but I will not permit this testimony at this particular time. Anything else on behalf of the defense or the state?
Not on this issue.
Okay.
I have a brief issue that I'd like to bring to the court's attention.
Yes, sir.
Today, we were handed by the state of Florida discovery, which included 2 compact discs.
Okay, we'll take that up at noon
Yes,
on
sir.
your lunch hour.
Yes, sir.
But we got a jury that's sitting there. Yes, sir. Yeah.
And I want to also make sure that he's removed from the PowerPoint any issue, anything related to the issue about DNA from decomp fluid needs to remove from the PowerPoint.
I believe we're ready, Judge.
Okay. All right, let's return to jury. Okay, Madam Clerk, may you swear the witness, please?
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
I do.
Okay, ladies and gentlemen of the jury, let me give you the following instructions. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reasons for those opinions or conclusions, and 3, any data or other information considered by the witness informing their opinions or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. You may proceed.
Please, the court. Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Mr. Eichenbohm.
Morning.
Actually, can you state your name for the record?
Richard Eikelenboom.
And introduce yourself to the ladies and gentlemen of the jury. Sir, what is your profession?
I'm a DNA scientist.
Okay. And you have an accent. Where are you from?
Oh, I'm from the Netherlands, so I apologize for my accent.
Now, can you give the ladies and gentlemen of the jury a little bit of your educational background? Can you explain that to them?
Yes. I started working for the National Lab in the Netherlands, which is at that time was the only laboratory doing all the homicide and crime cases for the Netherlands. In early 90s, and I started on the Department of Serology. The Department of Serology later became Department of Biology, because in the early 90s in the Netherlands we also started with DNA. So I started on the serology department doing protein electrophoresis and blood group typing, which is the front runner for DNA. So later on, I became more involved in trace recovery, so finding the stains.
What does trace recovery mean?
Trace recovery, well, actually for the biology department, is finding all kinds of biological cell material, which could be used for either electrophoresis at the time in the beginning, and later on could be used for DNA profiling.
And have you had any other training on DNA?
Yeah, I went to laboratory school first. That was analytical chemistry, so that was not really in the field of biochemistry. And then during my working for the National Laboratory, I followed an education on biochemistry. Okay. And that means biochemistry, you work with DNA and you try to decipher DNA. So it's all involving decipher DNA, so it's all about DNA.
Okay. Now I'd like for you to speak as close to the microphone as possible so everyone can hear you a bit clearer. Now, how long have you been working as a DNA scientist?
Around 20 years now.
Okay. And how long did you work for, was it the Federal Police Department of the Netherlands, or?
No, the Netherlands Forensic Institute is under the Justice Department. Our system is a little bit different from the United States. So I was working for the Justice Department for around 13 years.
Okay. And after that, where did you work?
In 2005 or 2003, my wife started the company Independent Forensic Services, and I joined the company in 2005.
Were you ordered to do that?
No.
Okay. Now, sir, can you explain to the ladies and gentlemen of the jury what the difference is between regular DNA and low copy number DNA?
Objection, Your Honor. The witness is not qualified as yet, and I have a question.
Okay.
I'll pass over for qualification for the voir dire, and then I'll continue. Michael, take that stuff. Take it.
Mr. Eichenblum, the highest degree that you have obtained is what's referred to as an engineer's degree in Holland. Is that correct?
That's correct.
An engineer's degree is something between a bachelor's degree, but not quite up to a master's degree, somewhere in between those two, correct?
That's what you could say, yes.
Approximately. Your degree is in biochemistry, correct?
Yes.
And your specialization for your degree in biochemistry was in the study of luminol, correct?
That's correct.
That's a substance that is that lights up to show where blood is, correct?
Yes, it reacts with oxidized metals.
Okay.
But it is used, in CSI a lot for finding bloodstains.
But you did not specialize in molecular biology or DNA in your biochemistry degree. That was not your area of specialization, correct?
That's not correct. Of course, the biochemistry education has biology, all kinds of fields and training in DNA and biochemistry. And then as a part of the last year where you do an internship, which of course was at my work, then I choose for a luminol subject. So that subject didn't contain much DNA. Of course, we were finding out, so actually it did contain quite a lot of DNA. What we tried to find is to make a new solution of luminol, which would not deteriorate DNA. So it had for sure something to do with DNA.
Now, when you were working at the same time you were in school, you were also working for the Netherlands Forensic Institute, Department of Biology. But you did not do DNA testing for that institution, did you?
I worked on the biology department, and the biology department is divided in sections. And during the time we're talking about my training, I became a coordinator, and that means that you coordinate cases, you get all DNA results, but it's all on paper, and I had you can have an accent on certain investigations. That could be DNA extraction, that could be analysis. My emphasis was on trace recovery.
Not DNA analysis or extraction?
No.
And in fact, though you had some training in DNA with the laboratory, you were not certified by that laboratory to perform DNA analysis, were you?
That's correct.
You did trace recovery?
Yeah, as an accent, and I coordinated cases and reported cases.
Coordinating cases means basically deciding which unit should get it first, how best to coordinate the various disciplines in examining an item. That's what you mean, correct?
And then you get all the results. So you have to know something about DNA in order to do interpretation. So analysis, in the sense you get the results, but you do the final comparison about suspect, victims, match or no match.
But you didn't actually perform, analyze, or interpret DNA cases during your period of time with that institution, correct?
I did a lot of interpretation. I did not do the performing the actual pipetting of extraction or analysis in the unit analysis. But
I see. But in 2005, your wife and you opened a business.
Correct.
Called Independent Forensic Services.
Correct.
And you and your wife appointed you as, quote, director of DNA.
Correct.
No further questions, Your Honor. We would object to his qualifications as an expert in this area.
I have more that I'd like to elicit from him.
Go ahead.
How many cases did you work where you actually recovered DNA and processed it in the Netherlands?
In the Netherlands.
Yes.
Processed the DNA cases, so that was during independent forensic services?
Correct. Prior to opening up independent forensic services.
Prior to?
Yes, yes.
So, what I said for the Netherlands Forensic Institute, I worked in, as a coordinator, I worked on a lot of high-profile cases, but then as coordinator, you get the results from the laboratory technicians. During the time with independent forensic services, we started doing everything ourselves. We didn't have lab techs. So, in that time, we did from trace recovery till the report writing and court testimony all ourselves.
And did you receive any training on how to do these, how to do both the trace recovery, extraction, and PCR process, and everything else that is required when running a DNA sample?
Yes, of course. We had during the biochemistry lessons, you get to know the DNA extraction. And in the Netherlands Forensic Institute, I followed all courses which were aligned to become expert witness there.
Okay. And was your lab, Independent Forensic Services, accredited by any organizations?
Yes.
Which organizations?
In Holland, we have a Dutch accreditation board, and that is similar to what you have over here as the ESCLET accreditation. That's a board which accredited DNA laboratory or for all kinds of laboratory, but in this case, DNA laboratories.
And do they require certain proficiency testing?
That's correct.
Okay. And what is proficiency testing?
With proficiency testing, you get a blind sample, and in this case, or in our case, we used CTS because that's an American-based company, collective laboratory testing. And they send out a sample, or more samples, reference samples, and as a crime sample. And then the laboratory has to perform DNA on that, and then send back the results without knowing whether or not they were right. And after you send that in, a couple of months later, you get results back, and you can see whether or not your test has been performed well according to 160 or more laboratories which were participating in that test. And till now, we always met the criteria of the other laboratories.
And have you has your laboratory been contracted by law enforcement from your country to do DNA samples?
Yes.
How many times?
Over 100 times.
Okay. And in addition to that, have you ever been asked to testify as an expert witness in the area of DNA analysis?
That's correct.
How many times?
Over 70 times.
I'm sorry?
Over 70 times.
70 times. Okay. And to get this accreditation, are there any other requirements that they monitor your laboratory and its employees?
The CTS testing is a very important one, of course, but also when the Board of Accreditation does a visit over here, I'm not sure. In the Netherlands, that's every year. I think over here it's once every 2 years. But in the Netherlands, every year they come by, and they also bring an expert, a DNA expert, a forensic DNA expert, who can say and review reports. They can actually ask anything from you. So in that way, you're reviewed very thoroughly.
Are you referring to audits?
Yeah, the audit.
Okay. And how did you become involved in cases in the United States?
The first case was the Tim Master case.
Okay.
Objection to reference to specific other cases.
The counsel's on this question, his qualifications.
So, State, you can ask him whether or not he's testified, but don't talk about a specific case and whether he's been qualified in courts over here.
Yes, sir. Mr. Eichenbaum, try and answer just my question. So you were contacted from a case from the United States, correct?
That's correct.
And what kind of case would you call it?
Objection doesn't go to qualifications.
I think it does.
Sustain. Rephrase the question.
Were you sought out for your unique expertise in any?
Move to strike.
Sustain.
Were you sought out for what reason, sir?
Objection. Relevance. Could we approach him?
Yes. You may proceed.
Thank you, Your Honor. Mr. Eichenboom, have you been sought out to handle cases in the United States?
Objection. Objection.
Sustain.
Have you testified as an expert witness in the United States on some cases?
Yes.
Where and how many times?
State of Colorado, 2 times.
Okay. And were these by law enforcement or defense or both?
I have to correct that. It's 3 times. Twice by defense, 1 time by law enforcement.
Okay. And you now have a laboratory in Colorado?
We're setting that up.
Okay. And the training that you've received in DNA analysis, where did you receive that training?
A lot of the training was in the National Lab in the Netherlands Forensic Institute.
Okay. What kind of courses?
All kinds of courses. It's a laboratory training. It's about interpretation, analysis, statistics, mood courts. So the whole field.
Would it be fair to say from the actual recovery of a collection of evidence all the way through the statistics of being able to interpret results you've received training on?
To the court, yes. So statistics
actually even through the court. Okay. And was this accredited training?
Well, I think it's part of the accreditation procedure. If the training itself is accredited, I don't know.
Okay. And did you also have experience in all different aspects of DNA analysis?
Yeah, maybe I should explain that the reporting officer, I was in training for reporting officer, And then you, of course, have to know everything about the topics about DNA, which you have to testify in court. In the Netherlands, because the laboratory or the biology department became so big, it was separated. So you did not, as a reporting officer, you don't have to work at DNA extraction or DNA analysis. In this stage, they have reporting officers which have never been in the lab, I think. So to become a reporting officer, you have a different training than if you only do trace recovery or you only do DNA extraction. That is done more by lab techs. So the difference was that I went from trace recovery to become a coordinator and to become a reporting officer.
Okay. So is it fair to say you've received training on all aspects of DNA?
Absolutely.
Okay. And that you have over 20 years experience on being able to identify issues on all aspects of DNA?
That's correct.
And you've been certified both as an expert witness 70 times in the Netherlands and 3 times in the United States.
Yes, that's correct.
And you've been certified as an expert witness in DNA analysis.
That's correct.
At this time, Judge, I would submit Mr. Eichenboom as an expert in DNA analysis.
Objection.
Witness would be accepted as an expert witness in DNA analysis.
Judge, would this be a good time to break for lunch?
It would be a good time, Mr. Baez. Okay. Ladies and gentlemen, jury, we're going to recess for lunch. I'm going to ask that you return here at 1:30. Do not discuss this case among yourselves nor with anyone else. Thank you. Okay, Mr. Baez, you said you had another issue you wanted to raise.
Yes, sir.
Sir, you may stand down. You can go to lunch. Be back by 1:25.
Sir, Judge.
Let's get the witness out. Make sure your staff tells him what time he needs to get back. You may proceed, Mr. Baez.
Your Honor, we were given this morning, which is the date, June 21st, 2011, some discovery that was provided to us by the state. In reviewing just a crude, rough peruse of what was given to us, it appears that many of the documents that were turned over were items that have just recently come up and certainly beyond the state's control as to being able to turn the items over, with the exception of one compact disc. This has to deal with some material from the desktop computer from the Anthony home, specifically ones that were taken from June 16, 2008. This report was completed on April 26th of 2008, but yet not turned over to us for 2 months later, after the time that the state's experts have already testified, computer experts that is specifically. In reviewing this also, I also noticed some photographs that appear to be some internet searches for what would be considered, and this is just one example. It's not the brunt of our objection and issue. But it appears that there are photos of shot girls, which may have been at one time viewed on the Anthony home computer. I found this particularly interesting because during Mr. George's direct examination, he on multiple occasions referred to Miss Anthony organizing or trying to collect or give advice on the clothing that the shot girls should wear, which also leads me to believe that the state had prior notice of this discovery, and that's the point why I bring that up. This is the law enforcement had this computer since July 16th of 2008, going on 3 years now, and this report is now given to us subsequent to the state's experts already testifying. We would object to any presentation having to relate to these items, and I'm specifically referring to the computer items, not to what was disclosed previously, or what was disclosed of recent events that don't appear to be relevant to this case, unless of course they do become relevant at some time. But we would certainly object to that, and I guess I ask for a Richardson hearing on the matter, unless the state does not intend on using this newly found, well, not so newly found evidence.
Ms. Burdick?
Thank you, Your Honor. The first several items on the notice of discovery deal with a brief investigation that was conducted at the end of last week. Apparently, a citizen called the Orange County Sheriff's Office, left some information about an inmate who may have had contact with Ms. Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from this witness. That transcript was produced immediately. I received all of that information yesterday.
What was the name of the witness?
The name of the witness is April Whalen. Apparently, her child died in a swimming pool and was found by the child's grandfather, who immediately administered CPR and called 911. Ms. Whalen was in an adjacent cell to Ms. Anthony for a very brief period of time. Ms. Whalen indicates to law enforcement she did not talk to Casey Anthony. However, she doesn't remember if she talked to other inmates. So at the present time, it's being explored whether or not there was indirect contact. Be that as it may, as soon as I received the reports verifying that, in fact, Ms. Whalen's son did pass away in a drowning incident, as well as the reports from law enforcement of the follow-up on the information obtained by or delivered by a concerned citizen that was provided to Mr. Baez in the event that it does become relevant in relation to the subsequent investigation or the investigation that continues. The last item that is on the notice of discovery is simply a filtered copy of items from the hard drive that Mr. Baez has had for years. My use of these items, or our use of these items actually, would be exclusively in rebuttal if Ms. Anthony or another witness were to testify about specific activity occurring on June 16th. An examination of the hard drive indicates there was substantial computer activity that would rebut a lot of what Mr. Baez said in opening statement. Therefore, even though he had this information for years himself and had a more than one computer consultant during the pendency of the case, as I recall, I decided that if we are going to use a demonstrative aid during the course of our rebuttal or even Ms. Anthony's cross-examination, that we would give that to counsel. And we have done so, rather than holding it for rebuttal.
Let me ask you these questions. I take it so we're all on the same page. This is contained in notice of provision of supplemental discovery dated June 21st, 2011, which bears your signature.
It does.
And items 1 through 6 all have to do with Miss April Whalen.
They do.
And that information was provided to you by law enforcement when?
The fact that they were conducting an investigation was communicated to me last Thursday or Friday, perhaps even Saturday. I believe they worked on this over the weekend. The written reports were delivered yesterday afternoon.
And so you delivered it as soon as you became aware of it and it was ready to be delivered.
That I did.
Okay. And the last item, item 7, is just a redacted version or demonstrative aid of an item that you had previously given to the defense.
The defense had their expert actually travel to the Orange County Sheriff's Office or provide a hard drive to the Orange County Sheriff's of the HP, the desktop computer in the Anthony home over 2 years ago. And the information contained on the hard drive is, of course, voluminous. I would have expected that counsel would have concentrated on the items on the computer on June 16th. However, since we did that and would like to use some of the items on the computer as a demonstrative aid, rather than having the sanction of exclusion that was suffered as a result of not providing a PowerPoint, I provided this information at this juncture.
Now, do you plan to utilize Miss April Whalen?
Based on her statement, I would say no. However, as that information is investigated, there may be something from it that would be suitable for a rebuttal case. But at this juncture, as I've told Mr. Baez, that would be no. The court may not know. We continue to get phone call after email from concerned citizens, as I'm sure they do. We have to cull through that information to determine what are just fashion suggestions or prosecution suggestions and what is actual fact or Brady material. And we have been doing that on a regular basis. This was one of those items that was investigated. If it turns out to be something relevant at this juncture, I would say no. But it could before the end of the case.
Okay, as to items 1 through 6, Mr. Baez, any additional comments?
On those items, no.
Okay.
But I do have numerous comments on 7.
Okay, let me finish 1 through 6. The court will find that this is not a discovery violation. The court will specifically find that under Rule 3.220 of the Florida Rules of Criminal Procedure, that the state has a continuing duty to disclose information that becomes available to them. And also, under the case of Brady versus Maryland, they also have that duty which they have complied with. Now, let's move to item number 7, Mr. Baez.
Yes, sir. If I understand Ms. Drain-Burdick's position, they gave us a copy of the hard drive, so therefore they gave us, this is a filtered version of that. And I would equate that to giving us 50 phone books and telling us pick out page 700,631. The reports issued by experts in this case, and I guess we're going to get back to your order again, issued certain opinions, laid out certain dates, laid out issues that may or may show up or may not. As it relates to this date, the only thing that was issued by an expert witness was Sandra Kahn's testimony or report that states the hours of inactivity for the times of the computer search, computer activity on that day. Not who was on, not who may or may not have been on the computer, who may or may not have been home, and what exactly, what pages came up, and so on and so forth. There's so much data that we could be referring to, that it now appears that the state of Florida has decided to focus in on or use some evidence during their rebuttal case for which they had before the trial even started. In addition to that, there's no way, when we retain someone to verify the work of the prosecution in this case. So if they're going in a different direction and they issued other reports, especially given Your Honor's admonition and order, that's the area that we asked them to focus on, of course. And after determining that we would not be in need of a computer expert, we withdrew them from the witness list. So here we are without an expert witness on our case. They have had this information.
Just a second. Okay.
They've had this information for almost 3 years, and Ms. Drain-Burdick's response is, we've had a copy of the hard drive, so therefore we've had the information. And that's not quite accurate, given the circumstances of how much data a computer contains.
I know you haven't had an opportunity to review it, but Ms. Burdick, what's on this disk for 61608?
Contains all of the computer activity on the desktop.
From what I could see, it's scribbly data. Some of them have photos.
Items created and accessed on the HP, the desktop, on June 16th of 2008. Data that was available on the hard drive if they chose to filter it out themselves. Okay. Baez's opening statement focused on activity occurring in the morning hours of June 16th. The computer activity, as well as instant messages that were also sent in discovery years ago, negate that timeline.
Well, let me just simply ask this. Was information provided to the defense by the state of Florida on the computer activities on June 16, 2008?
No, sir.
So you didn't get the hard drive?
We got the hard drive, but that's everything, Judge.
Well, but they gave you all of the information, correct?
They gave us a copy of the hard drive, which contains billions of pieces of data, and they issued reports of what opinions their experts were going to render and what information they had.
Well, let me ask you this, and
if I may clarify something else, Judge. And as it relates to my opening statement, I specifically said the exact hour is unknown. So for the state to allege that this is information that would directly rebut that, again,
it would seem to me, as an outsider looking in, that June 16, 2008 was the last time that the victim in this case was viewed by her grandparents. It became quite evident, even though it is not evidence, that from the opening statement of the defense that the 16th was a day of great importance, and that a so-called timeline of activities dealing with Cindy Anthony as to how she spent her day on the 16th Lee Anthony as to how he spent his day on the 16th, George Anthony on how he spent his day on the 16th, and last but not least, how Casey Anthony spent her day on the 16th, and whether or not what, if any, activities took place on the 16th of June, on the 15th of June, and on the 17th of June, both on 24-hour cycles, would have been at least of a minimum requirement of review. And I take it at some point you did have a computer expert, I guess, regurgitate whatever was on that computer on some of those days?
Yes, sir.
And if my memory serves me correctly, didn't the state's expert talk about various entries on the 16th when his testimony? He testified to certain events, didn't he?
He did not.
No, he did some event searches for chloroform and other things on other dates.
Correct.
But all of that information came off the hard drive?
It did.
Well, if the hard drive was provided to you, then it was left up to you to decide whether or not what searches you wanted to do on that hard drive, and it was not denied access to the defense, and it was up to you to determine what days you chose to look at and what days you chose not to look at. And I'm trying to wonder, how could it be the fault of the state of Florida that you chose not to look at any particular date when you were given the entire hard drive, and you all knew what dates had some relevancy to this particular case?
I can tell you that we took your order to mean that all opinions that experts intend on rendering must be in a written report, and the basis for that opinion, all of this must be turned over to the defense.
Well, tell me what someone out of the state of the defense enlighten me as to what is the expert going to tell us other than extract, because most folks are not computer savvy. Some people are, some people are not, that can go in and tell us. All they're going to do is bring it up on the screen as to what activity occurred on that particular date. Generally, computer experts, when you want to render opinions, basically render opinions about whether or not somebody has tried to hide something or somebody has tried to doctor something. And, you know, that's what they generally do. But
can I add another point, Your Honor?
Yes, sir. Remember, y'all take as much time as you want to, because we're going to start back at 1:30.
Yes, sir. The issue here, as well, is we're giving computer information after the state has rested. We have withdrawn our computer experts from the witness list because we expected them to testify to what was in their reports and not to new evidence that was now given to us. So if the court's even considering this, allowing them to testify, we would certainly ask to have our experts, given the opportunity for our experts to review this material and see if at all it's...
They can look at it, but it's not new evidence. I don't know how something can be new evidence when it was given to you. Now, what you choose to do with it after you get it is your business, but it's not new evidence.
Well, I disagree, but we can argue that issue at a later time, Judge.
Okay.
I would like more time to review the material, give it to our experts, and then
You're free to do that.
see if we have further points to make.
Okay. Anything else y'all would like to discuss?
Nothing further.
Okay, see you at 1:30. Okay, you may be seated. Okay, let the record reflect that the defendant is present, along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed?
Yes, sir.
Let's return the witness.
While we're doing that, Judge, can I make a humble request?
Yes, sir.
I realize we have a short day tomorrow, but we would request that the court inform the jury that it is due to your honor schedule, not the defense, so
I will
they don't hold it against
happily.
us.
Did I tell them the reason why?
No, you didn't. No, you didn't, sir.
No. I will gladly do that.
Thank you, sir.
It also occurred to me that the court had discussed at some point saying something to the jury about witness Rodriguez and his not coming back, and I didn't know if you recalled that, but I think at some point you do.
At some point, we're going to need to do that, so y'all might want to consider crafting some language.
We have probably some further inquiry that we'd like to approach on that topic. We're discussing that amongst the team now. So,
you want me to explain to them about the half a day when they come in now? Because I may forget later on.
That's fine.
Okay. Let's return to jury. Okay, good afternoon, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay. Remember tomorrow, which is Wednesday, we will only work until noon or shortly thereafter. The reason for that is because I have a long-standing commitment for tomorrow at 1. And to give you a brief explanation, it deals with the state trial court's budget, which I serve on the executive committee of the Trial Court Budget Commission, which is having a meeting here. They have a meeting the next day, which I will miss. But that meeting is very important for the well-being of my circuit. That's where we discuss the distribution of funds for the next year. So I just want to make sure that we are represented when the bargaining begins. Okay? Mr. Byers, you may continue.
Thank you, Your Honor. May it please the court. Mr. Ashton, good afternoon, ladies and gentlemen. Good afternoon, Mr. Eichenboom.
Hello.
Okay, we're going to talk about DNA. Now, sir, can you tell the ladies and gentlemen of the jury, give them an example of what touch DNA is?
Well, touch DNA means you have all kinds of DNA. Now, everybody knows about blood, saliva, semen. Touch DNA is DNA which is transferred mainly through the hands. So if I touch an object, I will leave DNA.
Is there different types of touch DNA, or actually, let me rephrase that. That's a poorly asked question. What affects how much DNA when you use touch DNA is left?
There are different factors which will decrease or increase the chance of obtaining a DNA profile. If I touch this table here very slightly, the chance of obtaining a DNA profile is very, very remote. The upper layer of my skin contains DNA cells or contains cells, skin cells. But these skin cells are dying cells. I actually have this in the presentation. Not sure.
Your Honor, may we, the witness has a PowerPoint presentation that would assist him as demonstrative aid. May we publish that?
You may. What's the exhibit number for the demonstrative exhibit? Attach the exhibit number.
27.
Okay. It's for demonstrative purposes only. You may.
I don't believe it would be an item in evidence.
It's not in evidence. You just need to have an identification number, Madam Clerk.
So, actually, it's on his. It's a disc. I can.
Okay.
Give you a
we just
disc.
need to reference it at some point. It's a dish, but we just need an ID number for it.
Yes.
Okay.
CI.
And just label it a demonstrative exhibit.
Go ahead and bring it up.
Okay. Just without the slides.
No, you can bring up your PowerPoint presentation if it helps you. May we publish this to the ladies and gentlemen of the jury?
You may.
It's visible for you.
Hold on a second. We're going to make sure we can see. Can everyone see? Oh.
Yeah, it's a delay.
Oh, okay, great.
Okay, go ahead and explain what we're looking at here.
So, yeah, the first slide was the common types of DNA everybody knows about and hears about. The second slide is about skin cells, epithelial cells. And these epithelial cells are the covering cells of the organs. But mainly when we talk about touch DNA, we talk about, of course, skin cells from the hands. If we go to the...
So when you say epithelial cells, you're referring to skin cells?
Epithelial cells is every covering cell. That could also be the mucosa from the mouth, or the covering cells from the lips, or vagina cells. But for touch DNA, yeah, we mainly talk about skin cells from the hands.
Okay.
Where we are
and what are we
interested in.
What are we looking at here?
In this slide, you can see the top layer of cells doesn't contain any nucleus. That is the part of the cell where we do get our DNA from. So that means that if I touch something, I will leave this top layer mainly, which is hardly containing no DNA material. And of course, in order to obtain a DNA profile, we need cell material or cells which contain the DNA. If you look a little bit lower below the top layer, you can see that there is, you see these kind of square bricks.
And that's this section here that I'm highlighting.
Yeah. Okay. So under the pink and under the blue ones, you see this section below that. And in the square, those are cells. In the squares, you see a small oval, round.
That would be this section here, the spinous layer.
Oh, you're signing on it. Yeah, but also in the granular layer, you see a round circle, and that's what we call the nucleus. And that nucleus, that contains the DNA which we need in order to obtain a DNA profile. So in order to get DNA from skin cells, you can see that if you only have a slight touch, the chance of obtaining a profile is very, very remote. If I apply more force, and of course that happens more often with violent crime than a casual contact where you just touch somebody on the shoulder or touch the doorbell, then the chance of obtaining a DNA profile increases. With blood, saliva, and semen, we all have presumptive tests. These are tests which gives us an indication that blood, saliva, or semen is present.
Would that be like a phenolphthalein test?
Yes, that's correct. Okay. But there are lots of tests like luminol or fate biles for saliva, or it's like phosphatesmo for enzymes which are present in semen. So you have all kinds of tests. The problem for the epithelial cells is that there's no test. So we get into a problem in detecting these cells. One possibility of detecting the cells is using an alternate light source. You see this on CSI all the time. They use a darkened room with the blue light. Well, that's what we call an alternate light source. And then if you wear orange goggles, then body fluids can fluoresce. And especially body fluids like saliva or semen or urine will fluoresce very well. A little bit less than these three I just mentioned is the sweat. Sweat also fluoresces. If you will look under the armpits of a t-shirt, you can see that very well. But sweats from the hands are a problem because there's not coming so much sweat from the hands. So if you touch someone or an object, there will be sweat there, of course, depending on conditions like it's warm outside or I'm heavily sweating.
What about sweat from the face and the forehead? Does that show up fairly well?
Well, it depends. I just touch it once. It's very difficult. So in a lot of times you don't see it if you use the alternate light source. But at least we always try first, also in this case, see if we see certain stains with the alternate light source. And if that is sweat, then that could give an indication that somebody touched the location and maybe left also skin cells there. So you're not detecting the skin cells then, but you're detecting, you try to find sweat. And then you assume or you make a working hypothesis where you think, okay, where there's maybe sweat, there also could be skin cells. Well, if you don't have that, and in a lot of cases we don't find that, then you alternative way of taking samples, and that's why you use a working hypothesis. And you look for locations where force was applied. If, for instance, you have a rape victim and the shirt was torn apart, then you can look at certain locations where you can see, okay, it is very likely, or there is support for hypothesis that this is the location where a perpetrator might have grabbed the shirt and torn it apart. So force was applied, and that also means that the chance of obtaining a profile is bigger. So that's not a possibility. Still, you don't know for sure that there's skin cells there, so you have to do the testing in order to find out whether or not you get a profile. Then the second problem which you encounter, it's difficult to find, but it's also very difficult to obtain a DNA profile. As said, these dying cells hardly give a profile. With blood, saliva, and semen, in more than 95% of the cases, you will get a profile. With skin cells, it's different. It's far less, depending per laboratory, but, well, I think 50% would be a high score if you make it as a laboratory. So
let me stop you there. How do you combat these problems? How does a forensic scientist actually find these types of cells and this types of DNA? What kind of tools are available for that?
Well, as I was going to explain, we formed a working hypothesis, and then you can use a number of amount of methods in order to obtain cell material or DNA from those cells, even though they're broken down so much.
And how would you go about that?
That's the next slide. The point I want to make here is that the type of contact of force is very important in order to on the chance of obtaining a profile. And then we have three different types.
So let me see if I understand what you're saying is you end up developing a working hypothesis by taking a look at the scenario and the type of contact and the location where that contact would be. Is that a fair statement?
Yeah, that's correct.
Okay. And starting from there, what do you do next?
Well, this is going into, you don't want to see this about the three types of contact?
Sure, go ahead.
Okay. Because I think in the Netherlands, at least, we use three types of contacts. And then you have due to wearing, which of course is very often people wear clothing for a longer time, prolonged time, and watch. And then you have the forceful grip, which is of course more related to crime scenes and crimes. And then the contact due to touching. Due to wearing, you can understand that there's not so much force applied, of course, when you're wearing your clothing, but there's a prolonged time, and these clothing or items are more or less rubbing against the skin for a prolonged time. So you can understand that over time, so the longer that takes, the more DNA will accumulate and you get a profile. And then these are a couple of examples like knife handles, clothing, watches, which would give profiles. So this category is the highest category of chance of obtaining a profile. The second category is important for crimes, because if a suspect doesn't know the perpetrator, then or a victim doesn't know the perpetrator, then of course it would be interesting to know whether or not you could find DNA on locations where a perpetrator might have touched the victim. This is talking about forceful contact, so now I'm not only touching it, but I strangulate someone, or I grab somebody very hard by the arm, or by the shirt, or by the trousers. So I go through the topper layer of the skin cells, the dead skin cells, but then now I come into a layer of skin cells which contain DNA. And then the third one is, I already explained, just a slight touch, a doorbell, a pen in a bank. Those is the worst category of chance of getting a DNA profile. There are a couple of factors which are also important. Some people shed more DNA than other persons. It could be that somebody has a skin disease, or somebody is just shedding a little bit more. So a good and a bad shedder means that some people who donated more cell material when they touch something, we call it a good shedder. You also have people which, if they touch something or they even apply force on something, you don't get a profile from. They just don't give enough cells with DNA in order to obtain a profile. As explained earlier, long and short contact, the longer the contact, the bigger the chance of a profile. Strong, weak, also explained. And of course, you can imagine if you have a very rough object, it almost etching your skin, then of course you will also go to the top layer of the skin cells and you will grab material from the skin which contains DNA. Of course, two separate parts is that a sticky material, for instance, we have a method in which we use tape to collect DNA from clothing. So sticky material, of course, will also help to collect DNA better than just a smooth object which touches something. And
okay, let me stop you there because I want to try and tie it in a little bit to this case. So let's take a piece of duct tape, for example.
Yes.
If a person were to cut a piece of duct tape, would they have to grip the non-sticky side in conjunction with the sticky side to cut it?
If you cut it with your bare hands, then you get two locations. Of course, the sticky side where you have one finger and the other side where we have the other finger.
What type of pressure would be required to cut duct tape?
Well, it's more than a slight touch.
Injection outside his area of expertise is pressure taken to cut duct tape.
Sustained.
Have you had to ever recover DNA from duct tape before?
That's correct.
Okay. And do you find in your experience that you can sometimes get DNA from the non-sticky side?
Well, you have different types of sampling. Mm-hmm. And with the duct tape, if we know a location where, or we have in the working hypothesis location where it was torn off, and you can see that every now and then because the tape is more or less worn out, it's like stretched. Mm-hmm. Then we take a sample, and from those locations we are able to obtain a DNA profile.
Okay. And which side of the duct tape would be the most prone to being able to retrieve a DNA profile from? Well, the sticky side or the non-sticky side?
Well, the sticky side, together with the force, of course, is the best location, because then you not only have the force you apply, but also the sticky material, and especially with duct tape, which is known to be very strong adhesive. Yeah, you will collect more DNA, of course.
Now, given the hypothesis that the sticky side of duct tape was applied to someone's face, what would you expect to find in regards to DNA on that?
Objection to hypotheticals not involving all the facts of this case.
Overruled. Yeah, we had several cases where duct tape was used in robberies and that kind of and homicides as well. And the duct tape or the tapes, because it was not only duct tape, were fit for DNA.
What kinds of cells would a face, if it were covering a mouth and a mouth area, would you expect to see? What kind of cell material gets on that tape?
So if you cover the mouth, then of course the skin around the mouth. But then, as I mentioned earlier, if you cover the lips, the lips are wet, and there are also epithelial cells there, and of those. You all heard about the buccal cells, which are used for reference sample. So there's a lot of DNA in the mouth area. So those buccal cells are also very good for obtaining a DNA profile.
Now, given the scenario and the facts of this case, have you formed an opinion as to whether if duct tape was applied to this child's face, given the fact that it would have been applied forcefully and the stickiness. Do you have an opinion as to whether you think DNA could have been collected from this sample?
Objection. Compound question, and there's no clarity as to what facts this witness knows about this case that counsel's asking about.
Overruled.
Go ahead and answer.
If the tape was put on the mouth and then was removed, it's about the case or it's just in common now. If you would put tape on a face, you would get, it's very likely you would get a DNA profile.
Objection. Counsel, the answer is not responsive to the question about, you could explain more at the bench. He indicated tearing it off, which is not the fact of this case.
Yeah, that's his answer.
Let me ask you it in this way. If you had duct tape placed over someone's face and mouth, and that person died and was placed in a wooded area, even with the elements of an outdoor area, would you still expect to find DNA on that duct tape?
So at the start, of course, if you put it on the face, you would expect quite a lot of DNA there. Okay. Of course, the circumstances of in which a sample is contained, and of course I'm talking about the whole duct tape now, if it is in bad conditions, then DNA could break down. But, well, I had it later in the presentation, but of course with the PCR techniques, which are very sensitive, you could expect still to find DNA.
Okay. Go to the section of your presentation, because I want to try and keep it as directed to the issues for the jury. So let's go straight to that portion of your presentation so you can explain to the ladies and gentlemen of the jury why you have that opinion. Yes.
Okay. So what we do with DNA investigation, we investigate certain locations on different chromosomes, and those chromosomes contain information in which you and I are different. So because of these differences, we can make the difference between certain donors of DNA material on a crime scene, for instance. We amplify DNA, so we don't completely clone a person, but we look at small locations. And if you look at this picture, we have these small locations in the nucleus, on the chromosomes, where we do DNA investigations on. And what we do is we amplify those small locations. So now we have, with standard conditions, millions of copies of these couple of DNA or fragments which are present in the sample. So you start out with taking a sample, for instance, from the tape. You cut out a piece, or the FBI did swap a location, and then we have very little DNA. So what we always do is we amplify the fragments of interest. And that's what you see over here. You get all these fragments and we amplify them. Normally that's done between the 28 and 30 cycli, which means we have 28 to 30 amplification steps of these small particles of DNA. And then at the end, if there was DNA present in your tube, this DNA is amplified. Is that answering your question here?
Yes, go on.
In order to make it a little bit more clear, is that we can, theoretically, one cell is enough to get a DNA profile, not with standard conditions. So let's say between 50 and 100 cells are enough under standard conditions to obtain a DNA profile. That means that you cannot see it. So in this picture you see a slide. Well, you don't see, go back. You cannot see what's on the slide, but still, if you look under a microscope, you would see cells, and that would be more than enough to obtain a DNA profile from.
Now, let me stop you there, because I want to stay on the duct tape for a moment. Now, were you made aware that there were 2 partial profiles on this duct tape, specifically the Q63 duct tape that's been admitted into evidence? Evidence 302. My question to you, there were 2 partial profiles, one on the non-sticky side and one on the sticky side. Take this hypothetical for a moment. If on and now I'm only speaking about the non-sticky side, if the non-sticky side was contaminated, is there a possibility that contamination could override DNA that's already there?
If you have large amounts of DNA, then it is possible that you don't see peaks or alleles, what we call them, from small amounts of DNA.
And did you have an opportunity to look at how much DNA was there from the contamination?
The contamination peaks were around 150 RVUs. I have that in explanation later, but that's the RVU is a measurement which DNA scientists use in order to get an indication about the amount of DNA. And 150 is not very high.
Okay. So, is there the possibility that there could be lower DNA masked by that, or does that rule that out completely altogether?
No, it's never ruled out, and what you see is that there's some disbalance in some of the peaks, which can mean that DNA of another person is present, but this disbalance can also be there because of the low amounts of DNA.
Do you have an opinion on that at all, as to whether that's possible, likely, or anything like that?
Well, I would have investigated the evidence a little bit further.
Response to the question.
Okay. All right, let's go to the to the sticky side. Are you aware that there was a 17 allele identified at the D3 marker?
Yes.
Okay. And when I say marker, I'm referring to a location that is tested for DNA, correct?
Yes.
Okay. And a 17 allele, can you tell the ladies and gentlemen of the jury what that is?
Well, an allele could be described as an appearance on a certain locations, what already mentioned, the marker location on a chromosome. And the alleles are the appearances in which you and I differ. So, and that's written down in reports very often as numbers. And you and I have the different numbers. So that's what that more or less contains.
Now, do you show how much DNA, how many RFUs are from that 17 allele?
I have it in the presentation.
Okay, can you bring that up? Okay, what are we looking at here? It looks like some kind of a heart monitor.
Yeah. On the picture you see different peaks, and the peaks which has a number, or the amelogenin, which is the
sex chromosome.
Yeah, the location where you can see the sex type of the donor of the DNA.
Okay.
So the computer is analyzing the data and is assigning these data. And what happened is that there was an assignment with the 17 and with the X location on amelogenin.
Now, because these are at such low amounts, is there limited information that you can get from this?
Yes, of course. What we try to do is to obtain full profiles. So the more information, a normal peak profile or electropherogram contains much more peaks, with much more numbers below them. And that would, of course, give much more information about the donor of such a profile than if you have only one or two alleles.
Do you have an opinion after examining this electropherogram whether this is what is called an artifact, or is it or can you determine whether it's human DNA?
It's a small amount, but looking at this electropherogram, that I would say it's caused by human DNA.
Okay. Now, have you ever had the experience in being able to extract DNA from maggots or flies?
Yes.
Explain to the ladies and gentlemen of the jury how that's done.
When the maggots feed on human material, then it's possible, of course, that in the digestive system, if they feed on, for instance, blood, then of course there's cell material in there which contains DNA. If they consume that and it's in their system, then it's not completely digested at the beginning. So when you dissolve or extract the DNA from this complete insect or from the larvae, then it is possible that you obtain a DNA profile.
Okay. And tell me what kind of effect chloroform would have on being able to extract DNA, or would it degrade DNA in any way?
No, one of the methods used for DNA extraction is the phenol chloroform extraction. It's not so often used in Europe, but it's quite often used in the United States. And in that method, DNA is extracted with the help of chloroform and phenol.
Okay. So chloroform would never be able to affect being able to actually extract DNA that may be there.
I would not say never, of course. If you put DNA in a bottle of chloroform, that wouldn't help the DNA. But it's not that if you apply a little bit of chloroform, which is of course a volatile substance, that your DNA would be broken down like you have with chloride. So that's the difference.
Okay. I have no further questions, Judge.
Cross-examination.
Sir, if you could just leave that up for me. Sir, do you have a PhD?
No.
In fact, you're presently a student.
Overall.
You're presently a student at the University of Denver seeking your PhD. Is that correct?
Correct.
Under the supervision of two other professors who are experts in the area of touch DNA, correct?
They are not expert on the touch DNA.
Oh, what is their area of expertise?
They're in the biology department.
Well, I mean, I assumed that, but what is their area of expertise? They're your PhD advisors, right?
Yes.
What is their area of expertise?
Well, Dr. Phil Danielson does forensic DNA, and it's mitochondrial DNA, for instance.
Right. And you're under their tutelage trying to earn your PhD?
Yes.
Okay. Your laboratory that you've discussed, the one in Holland, the one that you became the director of, you and your wife started that, correct?
Correct.
Sort of a mom and pop situation, just the two of you. I'm sorry, that's an American expression. I'm part of it. In other words, the two of you started it, and you were the entire company. The two of you.
No, actually, the IFS was started with my wife and a co-worker from the National Lab, and I joined in 2005.
Okay, so three of you.
Yes.
Okay, and your laboratory is actually in a converted barn. Is that correct? Correct.
Part. We bought a farm, and we rebuilt the farm.
Right. And you converted and retrofitted it, the barn, in order to make it into a DNA lab. You have, secure facilities and all that kind of thing.
Yes, so we changed everything into a normal DNA facility, which is accredited as well.
Right. Now, in 2008, approximately, you and your wife decided to expand your business to the United States, correct?
Yeah.
And this was a business decision because there's a great deal more work potential in the United States than there is in Holland, correct?
You have more homicides over here, yes.
And you would agree, would you not, that the exposure that your company, that hasn't started yet, will get in this case is going to be extremely helpful to the future of that business venture? Wouldn't you agree?
Well, I'm not so sure about that, but we already work in the United States, in more than 7 states, and we're very busy with cases, so we're not really waiting on cases. The cases have to wait till we are finished. Our turnover times are more than half a year. So, no, we don't really need a lot of more attention.
But your laboratory isn't even open yet, is it?
No, in the United States.
In the United States?
The cases which we work on in the United States, we still do that from the Netherlands.
Right. And when you open your laboratory in Colorado, in the United States, it would be really nice to have a lot of work, wouldn't it?
We already have a lot of work, so actually we're trying to downscale it a little bit.
I see. And you're, the more work you get, obviously the more money you and your wife make on the new project, correct? And that's why you opened it.
Well, we're not really working always for the money. We have cases which we did for free, and so we rather work for in the way that we can work like we want to work. So we want to be able to work the way we want to do. And if we business-like, if we wanted to expand, we could have expanded way much more than we did now. But the problem is it's very difficult to get good DNA which can do this contact DNA, which we do a lot. In the way we want it. So we choose to be not too big.
Do you do something that's different than other laboratories? Let me strike that and ask another question. How many laboratories are there in the United States that do the same thing that you do?
I think it's growing now. I know that Bodhi Technology tries to do something about contact DNA. I know that the American New York laboratory started to do contact DNA. Also use low copy number DNA. And also the laboratory in Denver is start using more sensitive methods like we use.
Now, Bodhi Laboratory, that's a large laboratory. That's not a laboratory in a barn. It's a large concern.
Laboratory, yes.
Okay. So there are a number of laboratories in the United States that could do exactly the same thing that you do.
I don't agree. I think we have more experience than the other labs.
Explain to the jury what you mean by that. I mean,
well, With this contact DNA and touch DNA, objects which were worn by victims, what happened is that I think the first time we started with that in the Netherlands was 1997, and in 2000, the United Kingdom, or before 2000, but in 2000 we started research on low copy number DNA. The low copy number DNA means that you have the amplification, but you do more amplification cycles than the standard method used. In the United States, this method was, well, actually not used, I think, till recently. In 2002, we validated the method, and in the national lab, I was working on high-profile cases, and I used it in every case which I couldn't not solve. So if we don't have DNA results, and very often then, if there was contact between a victim and a perpetrator, what you start doing is looking for contact DNA. But in order to do this contact DNA, you needed low copy number, especially in that time, to work more sensitive. Well, that didn't happen in the United States, and therefore, I think in the United States, the main state laboratories used mainly DNA from blood, saliva, or semen. But at that time, because I worked all these difficult crimes, we got a lot of experience with this contact DNA.
Did you invent the protocol and process of low copy number DNA?
No.
Where was that invented?
I think the Forensic Science Society laboratory, which is currently closing, I think, but I think they started the experiments.
Where is that?
United Kingdom.
You use a particular, do you use a particular kit or protocol that you purchase from some location in order to do this low copy number DNA you're talking about?
Well, in principle, you can use every DNA kit because the method is only amplifying more than the standard number of amplification cycles. So you can do it with every kit. We use different kits, especially the last couple of years. Some new kits came on the market which are more sensitive.
And you buy those from Applied Biosystems Incorporated?
That's correct.
Which is an American company, correct?
That's correct.
Now, let's talk for a minute. You said you can do things other people can't. Explain, let me strike that. The only thing you do extra is you run additional runs of let me start back again. PCR is the process of replication of DNA, correct?
Correct.
Normally, you said, I think in one of your slides here, normally it's a run of 26 to 30 runs of this replication process.
20 to 30, yes.
Okay, 20. And the way that works is it takes, basically the first run takes one intact cell of DNA, one intact strand of DNA, and creates a copy. So it makes two.
Yes.
Right. Next run, 2 becomes 4.
Yes.
4 becomes 8.
Yep.
It becomes 16.
Yes.
And beyond that, my math skills fail me.
32, 120.
Right, exactly. So by doing this 20, 22, 25 times, you make hundreds of thousands of copies of this DNA.
Idealistically, of course.
I'm sorry?
Idealistically, of course.
Idealistically, right.
The problem with forensic samples is very often they're not like in a hospital. They're more difficult. There's debris or dirt in there which can inhibit the reaction. So you have to take in consideration. That's why I also say they already laboratory were able to get a profile from one cell, but forensically that's not really realistic.
Right. So theoretically you could get it from one cell, but yes, realistically you can't.
You need more forensically.
More than that. All right. I'm just trying to figure out what is there in that process that any laboratory with the PCR equipment can't do.
Well, it's the whole process. As I explained when we started the presentation, is what happened in the 90s was that a lot of emphasis was laid down on the DNA, the technique, and it was under scrutiny, and you were the first person to get DNA admitted. So there was a lot of problems around the DNA itself.
Sure.
Later on, after the techniques were refined and it was accepted in court, the problem became, okay, we have this very sensitive technique with the amplification, but we don't have the stain. So we have cases which we know a perpetrator had contact with the victim, but we didn't find semen or saliva or blood from this possible perpetrator. And that's when we started with the touch DNA, because we know there was a violent crime, the victim was killed, and in Holland that often doesn't happen with knives or bats. We don't have so many guns. So in a lot of cases there was contact between the victim and the suspect or the perpetrator, and we had to find this DNA. And then you come to the contact DNA.
Right. Now, you said that your methods were validated in 2002. Were these methods, or maybe I misunderstood you. I thought you said 2002.
I think that was in the national lab. So they did a validation study in 2000 already. And actually, when they were busy with the validation study, I used it in a high-profile case already. Okay. So from that time on, it was in the Netherlands. It was used in difficult cases, cold cases. I was project leader on cold cases. So I used it in a lot of my cases at that time.
My point, I guess, the original question I asked was that the only additional step that you do is you just take additional runs of the PCR method to make additional copies. That's the. Yeah. Is that correct?
No, I didn't answer your question correct, so I apologize about it. Now, the problem, the point I wanted to make was that with the sensitivity of the techniques, it is possible to get DNA. It became more important to find the DNA, and till the day of today, that's still the problem. In a lot of cases, it's certain that the perpetrator had contact with the victim was dragged, but they don't find the location. So, at that time, in 2000, it became clear that the technique was very sensitive, but you had to find it. And if you find something, or you had a location where you think, oh, this is a very likely location where the perpetrator touched it, you still, by a normal sampling method, you were not able to get a profile. So you had to play with the way in order to take a profile. For instance, over here I know the swabbing of clothing is a common sampling method. Well, in Europe this is hardly used because the results are not so good when you use swabbing. So we use cutting methods where you really pinpoint and you cut out a piece of sample and you dissolve the sample in the tube. And that's where we had a lot of success with cases, that we were able to find the right pinpoint location of DNA and then extract it in from that. But then, of course, the problem there is that if you have a piece of clothing, it could be that you need, if you don't know where to sample, you can take thousands of samples. And of course, as a state laboratory, you always are bound by certain amounts. You cannot do 1,000 samples on one item. So that was a big problem also in the national labs. You have to take the right position.
Well, my question really had more to do with the actual testing of the DNA, not the sampling. So I wasn't asking about the sampling, but the idea of running the test itself, it's simply a matter of running the PCR amplification for additional cycles.
For a low copy number, yes.
That's the only difference. Sorry. In that part. Okay. Now, let's talk specifically about a couple of the areas you've talked about. Counsel asked you about finding DNA in insects. Have you ever tested a particular insect called Megacelia scalaris, a fruit fly, a very tiny fly, and successfully obtained DNA from that type of fly?
No.
You indicated in your testimony that those situations where getting DNA from an insect is successful are situations where the food, that is the blood or flesh, has been recently ingested. And that if it's recent, that sometimes you can still find some DNA that hasn't been digested yet by the insect. Correct?
Yeah. Well, I think I have to adjust that a little bit, because the case we worked on and where we got the result was a 5-year-old case. So it's the remains where we got DNA profiles on. Whether or not at what time the insect died and or the pupae, the leftovers of the cocon, how you call it?
Cocoon.
Cocoon, where the insect is coming out. If they contain DNA, I don't know. But it could be in different stages. It could be that the insect or the larvae was dying at a moment, for instance, by drying, and that the DNA stays in there then.
Okay. But you did say in your direct examination that it has to do with some recency between the consumption of the food and the test, because obviously, eventually, the DNA is digested by the fly and is no longer. Right. Okay.
If it's digested, of course, the digestion of DNA, the digestion of DNA would break down, and the further the digestion goes, the more the DNA breaks down. And we measure small pieces, but of course, also with UV light, for instance, if you break the chain, you cannot amplify it.
Yeah. So basically, even if you were able to obtain DNA from a fly as small as Megacilius scalaris, if it had been a month or more since it had consumed whatever human food it consumed, it would not most likely be available. It would be digested.
If the fly consumed the blood or other cell material and then lived through and died at the end of his cycle, then the chance of DNA obtaining is of course small. If it died in between, before the consumption or the complete breakdown of DNA, then that's what I assume where we got the profiles from, is that, okay, then the digestion is halted, and then it's a way where the DNA could survive.
Have you ever done any published research studies on environmental effects on DNA?
I myself didn't.
You yourself?
No.
What is the most destructive environmental effect? What has the most destructive environmental effect on DNA? Number one enemy of DNA.
Well, it's a combination, I think, but moisture and temperature is a combination of moisture and temperature is a really detrimental effect.
So a hot, wet environment is the worst thing for DNA.
Yes.
And also the presence of bacteria is also extremely destructive to DNA, is it not?
Yes.
Would you agree, sir, that a piece of duct tape, well, let's talk about the duct tape for a minute. If you place a piece of duct tape on a person's skin and rip it off, it is likely to bring with it not only the dead surface cells, but the living sublevel cells, correct?
That's correct.
That's the point you were making on direct, correct? But when DNA is placed on a surface of the skin and not violently removed, then the cells that are in contact with the tape are, in fact, the dead cells. In direct contact with the tape.
Well, the dead cells, of course, the covering cells. I think that's correct.
Yeah, the dead cells are the ones that are up against the tape.
Yeah, of course, depends how much force is applied. But yes.
Okay. When it's torn off, it may pull with it some live cells, but what's in contact is dead. Correct?
Well, in order to tear the other cells off, it should be also into the deeper layer, I think.
I mean, assuming it's not torn off.
Yes.
That's my point. Okay. And you would agree with me, would you not, that duct tape placed upon the face of a human being, who is then placed in a semi-swampy, occasionally underwater, hot environment in Florida, in an area that is an erstwhile trash dump, and sits there for 6 months as every bit of skin cell decomposes off the body, leaving it completely skeletonized. You would agree with me, would you not, that the likelihood of finding any intact DNA on that tape is extremely remote?
Well, of course, the conditions which you describe are very bad for DNA. This is not a condition where you would have your DNA in. But of course, depending on different circumstances, whether or not you lose all of it, as explained, we only need a smaller number of a small amount of cells in order to get a DNA profile. So the question then is, okay, would you use all cell material? And that's possible, but it's also possible that still enough cells would be present to obtain a DNA profile, especially when using low copy number DNA.
But if there's no DNA on, when you test a bone for DNA, you don't swab the outside of the bone, do you?
No, if you want to identify the person of the bone, you cut out a piece of the bone or the skull. That's the two.
Scope. There was no bones brought up.
Because you don't expect to find any intact, recognizable DNA on the outside of the bone because it decomposes. Isn't that the reason?
The reason is that
Overruled.
Good.
The body mass on the outside of the bones, of course, during decomposition has more, the DNA is degrading much more there. So why we use the bone and the skull is that because the chance of obtaining DNA profile from those locations is much bigger than from, and I'm talking about decompositional bodies which are in late stages, so there's no good blood anymore, and skin and flesh are coming off the bones. That's the reason why we use it. Still, there is DNA in those locations, so it is possible, but it's way more difficult to get it from those locations, like for skin or the decomposing flesh or blood, than it is from the bones.
And while you have indicated that you believe it may be possible, you would agree it is extremely unlikely.
It will be very difficult to obtain a profile.
All right. Let's talk about this masking issue that you discussed with Mr. Baez. You indicated that contamination in a DNA profile can mask existing DNA.
Yes.
But it would only mask existing DNA at exactly the same loci, correct? So going by your chart here that you used from your PowerPoint, the only thing that this 17 allele would mask would be a smaller 17 allele, correct?
This is not the profile that we were discussing.
It's an example, Judge.
Overruled.
Correct?
So, with the lower 17, it's like 55. No, that would not be very likely. I think it was the other profile, the contamination, where...
Do you have a slide of that
of
profile? Put that up, and we'll talk about that.
So,
let me clear this.
This is a profile where there's more information visible.
Let me ask you the question then. Let's look at the various loci that we see here. Taking this 15 loci here, the only thing that would mask would be another 15 loci, correct?
That's correct.
It wouldn't mask a 14 loci.
No.
The same thing with the 16. It would only mask another 16. It wouldn't mask a 17.
No.
And the same could be said for each one of these loci. It would only mask its identical loci, correct?
Correct.
So in order for this profile to mask the profile of someone else, that person's profile would have to match at every single loci.
Yeah, it depends. What you see with the 17, for instance, what I already said, it would not be very likely that this profile is covering a full profile. So you will not lose a lot of information. What it would mask is, of course, the locations where you have the detection already, which you just circled.
Right.
And it's not so likely that a full profile would have been covered here. What could have happened is like a 17, well, in this case there's no 17, but like a 16 or 15. If you have a very partial profile caused by a very small donation of a other party, that could have been covered. So then you would not expect that this covers a full profile.
Right. There's no way this covers a full profile.
No.
This masks a full profile.
No.
The only thing it would mask would be identical alleles.
Lower. Of course, you see some alleles on this plate which are not mentioned, which are not detected by the threshold or by the analysis software. So therefore, you don't know completely if it's all these alleles. And also, if you look at this would be a good profile to enhance with low copy number DNA. Then maybe there would be extra information. So yeah, we would use this as a start for the investigation. So, okay, maybe we should do low copy number and see if we get more information there. Also, maybe with a third person. If you look behind the 15, there's a very small peak, but with low copy number, it's possible that you get a 16 there.
I'm sorry, you're talking about this?
The peak behind. No, that's in front.
I'm sorry.
That would be a stutter peak.
Hold on. Show me what you can tell us straight with yours on the bigger screen here. If you use your finger, no, the one right in front of you. If you use your finger, you can circle or tell us straight what you're referring to.
Okay. Oh, sorry, I'm not so good at this. No, behind the 15, you see a small peak, and of course.
When you say behind, that's where you're losing me. I'm not sure what you're talking about behind.
After? Just if you have the 15.
Talking about. That didn't work. Hold on. Let me get rid of this.
Sorry.
Okay, so just kind of put a little spot on what you're talking about.
Yeah, maybe I should just put it there.
Is it where you have your that little peak back there?
The second blue one, there's a small peak above that.
Well, there's a lot of small peaks in here, right?
Yes.
And you're saying that some of that could be noise.
Well, if you use the low copy number technique, it could be happening that you get information out of there. From this, it's correct, and the factory, I think, they use 50 as a cutoff for the analysis. Actually, the analysis is done by the computer mostly, and then later on, after the computer is finished analyzing, then a scientist comes and rechecks if all the data is correct or he agrees with that. So the data is correctly analyzed, but there's information there. If you look at these rounds, and these ones.
And what could those be?
So,
what could those be?
Those could be, I think if we use low copy number on these would go above the threshold and you would get information out of that.
What else could they be? If it's not DNA, what is it?
If it's not DNA. Well, these peaks can also be artifacts.
Okay. And again, your comments about what low copy number DNA could possibly do are completely speculative. You don't know whether it would come up with an additional profile or not.
Well,
Isn't that
pretty
right?
sure recognizing these locations. The peaks we see over here in the two circles are on locations where normally also markers are. So it's not pure speculation. That's that's the experience you need when looking over these profiles. Is that you recognize locations where you could get DNA extra information if you would use the low copy number method.
And every laboratory validates its equipment with certain limitations as to what will be called as an actual DNA peak versus what will not, correct?
Yeah, what I said here, it's the 50 RFU is a standard from the factory.
What is your RFU limits at your laboratory? Same?
We use the same.
So even in your laboratory, you would not call that as a DNA peak?
No, we would not mention this in the report, but we would enhance it.
You would potentially run a couple more runs of PCR?
Yes.
And then if it still didn't show anything, you would call it as nothing?
No, if the computer and the analysis software, which is highly sophisticated, don't mention it, no, we're not going to mention it.
Did you ask to retest this tape?
Yeah, we mentioned that we could investigate a lot of items.
But
unwitched the tape, yes.
Did you ask specifically to retest this tape?
Yes, we could retest the tape, yes.
It's not what I asked you. Listen carefully. Did you ask to retest this tape? Specifically this piece of tape?
To José Baez.
To anyone?
Anyone. Well, we mentioned that we could investigate this tape, yes. This piece of tape.
Are you aware if items were, at the defense's request, sent for additional DNA testing?
Object outside of the scope, and outside of this witness's knowledge.
Overruled.
Do you know?
Well, yesterday during the deposition.
Well, other than what
mentioned-
I told you,
Yeah.
because you can't really quote me.
Oh, okay.
Do you know?
Say move to strike.
I just told him not to quote.
Objection overruled.
Okay. So, aside from something I may have told you at deposition yesterday, as of yesterday, you have no idea if any item in this case was retested at the request of the defense.
No.
No further questions.
Redirect.
Mr. Eichenboom, you were asked about your laboratory being on a farm. Do you recall those questions? Your laboratory is actually known internationally as the crime farm, is it not?
Objection, Your Honor, as to what other people may call something.
Overruled.
Did I approach?
No.
Correct.
Okay. In fact, you've been sought out by other different countries to have DNA tested at your crime farm.
Objection, relevance.
Overruled.
That's correct.
And Mr. Ashton asked you about exposure. Your exposure, you've already had exposure internationally from your laboratory, have you not?
Objection, leading, and relevance.
As to leading, sustain.
Have you had any previous exposure just in the United States while you were in Holland prior to you being involved in this case?
Yes.
What kind of exposure have you received?
Objection, may we approach?
You may. Objection overruled.
Mr. Eichenboom, I want to talk about the recognition and exposure that you received prior to ever being involved in this case. When did you first start getting recognition from the United States?
Objection, it's not the question the court authorized him to ask.
Overruled, he can answer the question.
I can mention the name of the case. The first case was the Tim Masters case, which was an exoneration. We started with that case in 2006.
Okay, let me stop you there. What were you asked to do in that case?
We were asked to do contact DNA in that case.
And what do you mean by an exoneration case?
We were approached by a police officer who worked on a case, and she came to the Netherlands, or she was in the Netherlands on a visit, and asked, she visited us and talked about this Masters case, and she asked if we would be able and willing to do DNA in this case.
And was this to help free him from prison?
Sorry?
Was this to help free Mr. Masters from prison?
That's correct.
And what happened? What did you do?
We came over to the United States, talked with the defense team. Because there was no money at that time, we evaluated the case. I worked on quite some miscarriage of justice in the Netherlands, and thought, well, this could be a miscarriage of justice. So we decided to continue with the case. So, okay, we will, if the courts allows us, do contact DNA in this case. And I testified about contact DNA in the case, and the judge allowed the evidence to go to the Netherlands.
And the evidence came to the Netherlands, and what did you do there?
We did do the DNA investigation, trace recovery, and DNA profiling. And then we were able to obtain a DNA profile, which was not matching the person in jail, Tim Masters. We obtained a lot of DNA profiles, all not matching Tim Masters. In 2006, this was not much interest, or there was not a lot of media attention, but by the end of 2008, we were able to get a match with a suspect, or a former suspect in the case more than 20 years ago. And that was the time that they released Tim Masters, and it was the first miscarriage of justice which was acknowledged in the state of Colorado. And by that time, there was a lot of media attention.
Okay. And you received international media attention as a result of that?
Yes.
And that was from being able to obtain a DNA profile from 20 years past on Touch DNA?
Correct.
And this person was found outdoors?
Yes.
And the clothing that you tested was subjected to numerous elements?
Yes.
Okay. And held for 20 years?
Yes.
And then you finally were able to find something that wasn't found before?
Correct.
Okay. And subsequent to that, have you received other exposure from other cases?
Objection, leading.
Question is not completed yet. Overruled.
Have you received other exposure from other cases in which you have worked?
Yes. Because of this case, we got other cases from the United States, which also get some exposure in national media.
Okay. And did law enforcement agencies, as a result of that, travel to the Netherlands to consult with you?
Correct.
Okay. And were you able to assist them in their cases?
Yeah, we were currently working on several cases.
Okay. So this case is not the first high-profile case you've ever worked?
No.
Okay. Now, when you talked about running extra cycles and that's the only thing you do, there are actually kits that are sensitive, that are more sensitive than your standard kits when running DNA, is there not?
That's correct. I had it in the presentation, but shortcut it.
Sorry, I didn't mean. I'm trying to keep it as simple as possible. Now, when we say kits, we're referring to the type of what is used to try and generate the profile, correct?
Yeah, you could say these are the chemicals used in order to, of course it's a very complex procedure, but it's chemicals used to identify the different locations on the different chromosomes and make a profile.
Okay, and one example of this would be the minifiler
yes.
kit.
The minifiler is specially made for broken down deteriorated DNA, so that could have been helpful in this case.
And it's not just running extra cycles. There's also possibly extending the injection time?
Correct.
Okay. And there are basically techniques that you use that might amplify the DNA or make it a little bit clearer so that the computer reads it. Is that correct? That's a poorly asked question, I realize, but I'm trying to...
Well, I think it comes back to what I already described. The trace recovery is very important. And that was underestimated in the 90s. Everybody was looking at DNA. But if I have a big stain and I just cut it out and there's so much oil or grease in it, or especially metals with the PCR, it could happen that there's a lot of DNA there, but you still don't get a profile. So you need to have a lot of knowledge about the amount from such a stain. You cannot just say, I cut out 10 by 10 piece of centimeters of stain. So cutting it at exact right location with the exact amounts of pollution, and also with DNA extraction, which I didn't talk about here as well, but DNA extraction, what kind of method do you use? The phenylchloroform will not be able to perform as good as a cleaning action as, for instance, the QIAGEN material. So certain filters, we use filters to clean the DNA, that would also make a difference in the chance of obtaining a profile. So it's the whole process from finding the stain till the end, or till analysis, in order to gain success with the DNA.
Now, and another reason that you are able to generate profiles where other labs do not. Also,
assumes a fact which is not in evidence.
Sustain.
Move to strike.
Another thing that you
Just
do,
a second.
sorry.
Motion to strike granted.
Another thing that you do differently is, or another consideration is also the type of machine used to run a profile, correct?
That's correct.
Now, I know you have a slide for that. Can you bring that up and explain why that might help you generate profiles that other machines do not?
DNA is... Can everybody see this?
Yes, may we, Judge?
That's the same demonstrative exhibit number what, Madam Clerk? Okay.
So we see two machines over here. The one is slightly bigger than the other one.
They look the same size to me. Which one's bigger?
The right one is bigger.
Okay.
That will become visible if we look more closely. This is the 310, which we use. Is a smaller machine, and it's just one capillary.
And that's this line right here, correct?
That's correct. There's a line,
figure that out.
and actually this is a very small tube in which the DNA is separated, and then it's a laser detects fluorescent labels which you put on the small pieces of DNA, which we saw with the PCR amplification. And when the laser is hitting the label, it will fluoresce in different colors if it's a different mark or different location on the DNA. If you go to the bigger machines, they have 16 capillaries there. So now the laser has to go to 16 capillaries.
And that's these things right here, right?
So the ABI 310, you can see it in the text, and the ABI 300 are different in the way that the bigger machine has more capillaries, and that means that at the same time, where we do one sample, they can do 16. Well, one can imagine that for bigger laboratories, the state labs and the national labs, of course, they have lots of cases. And
Objection, Your Honor. This is not within the scope of cross.
It is actually, Judge. Mr. Ashton discussed that the only thing that he does different is run extra cycles. I'm pointing out that there are significant differences.
So the choosing of the machine is also of importance in order to get a profile. And we really tested this thoroughly because we do a lot of counter expertise in the Netherlands. So we test laboratory or do counter expertise on laboratory which use the, all the bigger laboratories in Holland use the ABI 3100, so the one with 16 or even more now. And we found out that extracts where those laboratories actually didn't get any result, we were able sometimes to get full profiles, partial profiles, but we get a lot of results. And the only thing different, because we're using the same extract because they made the extract, so the only difference in the whole method was the machine. So that's why how we found out that the machine makes a difference as well. And of course, it does make sense if the laser has to go to one capillary. This is a glass capillary. If it has to go to one, of course, it's more sensitive than it has to go to 16, because you can lose some power of this laser light going through. So the machine using that it's slow, so that takes time, and that's why I say we have a turnover time, which is longer, because we don't do 16 samples at the same time. We do one sample at a time.
Now, Mr. Ashton questioned you about degradation of DNA and how water and heat are bad for DNA. Do you recall that line of questioning?
Yes.
Have you found DNA profiles, and do you have any examples of what you can show the jury of profiles items that you've been able to obtain profiles in that have been exposed to these types of elements?
Do you want to see the slide?
Sure.
Yeah, in this slide you see 3 different kinds of pieces of evidence. You see panties, which is more than a pantyhose.
Yes.
On the left upper side, and that's a piece of panty which is more than 20 years old. And after 20 years, we were still able to get contact DNA from these panties.
Now, I'm a little confused because this looks like there's a lot of blood here. How do you know? I mean, isn't that just the blood the DNA profile that you got from the blood, or is that something?
The blood was from the victim, and of course, and it's more or less a given in the homicides we work on, is that you always have a lot of DNA of the victim. And of course, during our investigations, we're not looking for DNA of the victim, especially not on the clothing of the victim. So we're looking for DNA of possible perpetrators. And in this case, of course, and that's why the sampling is so important. If you take a stain straight into the middle of the blood stain, you will have an enormous amount of DNA of the victim. But what you need is the DNA of a possible perpetrator. So taking a sample on location, for instance, where there's less blood, where you're able to still enhance a profile of a second donor, that will help in order to get a profile. And that's what happened in this case.
Okay. And what else do we have here?
The second is the right hand of a victim which has been lying almost 3 weeks in the water. And also in this case, we were able not only to detect DNA from the victim, which if of course also 3 weeks in the water is in a very good condition, but also DNA from a suspect, which was later convicted, based also on the DNA.
Okay, and what about here, the jacket?
And the jacket is more or less the same. This jacket was not the body, but it was worn by a victim, which was lying in the water for around 3 or 4 days. And we were still able to obtain DNA from a suspect there.
So while, if I understand you correctly, while these conditions certainly don't help, they don't preclude you from being able to obtain a profile. Is that correct?
That's correct. Very often the bigger labs or the labs say, well, this has been in the water, we don't investigate it. And that's where we say, okay, well, give the evidence to us, we will try to investigate it. And then we were able to get DNA from that.
Okay. Now, you had requested to do DNA on items in this case, did you not? You were willing and able to do it?
Yes.
And you were willing and able to do it pro bono?
Yes.
Relevance.
Approach.
Just to move it along. Yeah. And the only reason you did not do the DNA testing in this case is because the prosecution objected to taking it.
Your Honor. Relevance. Yes, please.
Okay, we'll take our mid-afternoon recess to 20 minutes past the hour of 3. Please remember all of my previous admonitions. You may be seated. Okay, objection will be sustained in the sense that you can question him about the question that Mr. Ashton asked about did he ask to examine that piece of duct tape. I guess that was on the mouth.
Allegedly, sir.
Well, wherever it was.
Yes. Q62, 64 group of items. Yes, sir.
And as to the other issue that you raised at the sidebar about asking the court to take judicial notice of different testing, give me exactly what you want, because I am really going to need to research that because of the issue of burden shifting. There is a very delicate and fine line with that. And that's something that I don't want to have to deal with at the last minute, because if I get it at the last minute, I'm going to err on the side of being safe and disallow it. But I need plenty of time, because those cases are all over the board, and it depends on which group you have, and the cases have shifted from time to time, just as the composition of the Florida Supreme Court, or if you look at the District Court of Appeals, whichever panel you happen to get. So that is not a very easy legal issue to decipher. Some things are best left unsaid. We'll be in recess.
Yes, sir.
Okay, you may be seated. All right, both sides ready to proceed?
Yes, sir.
All right, let's return to jury. Okay, state recognized presence of the jury and the defense.
Yes, sir, we do.
You may continue.
Mr. Eichenboom, the 17 allele that was found on the sticky side of the duct tape, it was found at one marker, correct? The D3 marker?
Yes, 17.
And in order to include someone as a match, you have to have all 13 markers identifying that person, correct? For inclusion, I guess, generally speaking now.
No, what you normally do is you have a reference profile, and that's in the United States it uses 13 core loci, profiler, and ideally you would have a match on all those loci. With a partial profile or a very partial profile, as in this case, you can only compare a reference profile, complete reference profile, with the 17 or the locus D3 here,
now,
and the amylogenin.
Now, you testified earlier that you believe that this was human DNA, correct?
Yes.
17? Okay. Now, for exclusion, to exclude someone, how many markers do you need that is different from that person's profile? Did I ask the question?
As I understand correct, if somebody doesn't have the 17 in his profile, of course, if you don't have the 17 in the row of numbers of the 13 core loci, well, then you cannot have donated the 17. Is that what you mean?
Correct. So if I am a 14-15
yes,
at this marker, which is the D3, and a 17 shows up, could you exclude this person?
Yeah, you would not be the person who could have donated the 17 then, because it's not in your profile.
Okay. I have no further questions.
Recalls. Thank you, sir. Sir, one of the challenges with, let me restart. Original DNA testing was done with a system called restriction fragment length polymorphism, correct?
Correct.
And that system required a fairly significant amount of genetic material in order to get a profile.
Correct.
Sort of a quarter-size spot of blood or a bigger yes. or a substantial amount of semen.
Yes, correct. So for blood and semen mainly.
With advances over through the early 90s, this PCR approach became the approach used by most laboratories, correct?
That's correct.
Because it replicates even a small amount of DNA to make it large, to make it visible.
Correct.
As that has happened, the concern for contamination has become greater.
Correct.
In fact, the more the smaller amount of DNA you're looking at, the more difficult it is to relate it to the crime itself. Isn't that true?
That's correct.
So in other words, that you might find a speck of DNA through even just regular PCR or low copy number doesn't necessarily mean it relates to the crime.
No.
So the fear for contamination is much greater.
Correct.
Now, in this particular case, and I'm going to... I think Mike will be able to pick me up. If you had tested the tape in this case, there are 3 possible results that you might have achieved. The first is that you might have found nothing. Correct?
Yep.
And if you found nothing, that would not be inconsistent with the tape being placed on the child prior to decomposition, would it? Because as you said, the DNA could have simply degraded and decomposed, correct?
That is possible.
The other possible result is that you might have found Kaylee's DNA on the tape, correct?
Correct.
And that obviously would be pretty strong evidence that the tape was placed over her mouth before she decomposed, correct?
Correct.
The third option is you could have found an unknown DNA profile on the duct tape. Isn't that correct?
Correct.
And there would be absolutely no way to ever know whether that unknown profile had anything to do with the crime. Isn't that correct?
Well, I think the District Attorney was hypothesis, what we call it working hypothesis, was that the tape was crime related. So what you do with the DNA testing is test whether or not you get a result, and you can substantiate or refute, find support or no support for a certain hypothesis.
But my point is, if you got a result, an unknown result, a result that didn't match anyone that anyone knew anything about, you would never know whether that DNA came from something related to the crime or some contamination, which is very, very possible with low copy number DNA. Isn't that true?
Okay, low copy number DNA is more sensitive or prone to contaminations. That's true. We see that in the case we work in the Tim Masters case, for instance, we had a lot of contamination, which makes the whole investigation even more difficult. Having said that, what we do now is, and that's actually what the FBI also did, is testing that against all persons in which you know who worked on the case, the crime scene investigators, lab technicians, everybody who had contact with the evidence, you have a profile from. And I think in the United States also you have this database of profiles, not only from suspects, but also from lab co-workers. At least in Holland we have that. So everyone working on crime scenes or working in a laboratory has to give his profile and will be compared to obtained profiles. So if you can exclude, or there's no support for hypothesis that any of these co-workers contaminated the crime scene or the evidence, then of course it becomes more likely that it is in some way crime related.
Well, but because this test is so sensitive, you can't ever know whether somebody had contact with their wife and then got transferred DNA onto an item, because it's so hypersensitive. You just can't ever really know. Isn't that true?
Well,
you never really know.
No, it was low copy number. It's an issue which is more common. Of course, the type of transfer you described now is a lab technician having contact with his wife and contaminating the DNA with the DNA of his wife, but then still you would expect more DNA of this lab technician than from his wife. So this is called secondary transfer. Right. It's all possible. I won't deny that's possible. Secondary transfer is described, and there actually is literature about it. But it is less likely than direct contact, and so contaminations are easier found, and we, in the case we work on, we regularly find contamination by police officers or lab technicians. But then we recognize those.
course, the problem with low copy number is you may find unknown DNA, and then you'll never know whether it's contamination or an unknown suspect. That's the confusing part.
It's possible that that you don't find out.
In fact, that happens fairly frequently, where you get an unknown profile with low copy number DNA, and you really don't know where it came from.
That's possible.
Could you pull up that slide that you pulled up with Mr. Baez, the one with the jacket and all that in it?
Demonstrative exhibit by the defense, number what, Madam Clerk?
CI. Thank you, sir. The first object in the top left, was that associated with skeletonized remains?
No.
The object to the right, that obviously is a human hand that is not fully skeletonized. There's still tissue there. Is that correct?
Correct.
And the jacket that we see here, was that associated with fully skeletonized remains?
No.
No further questions? Oh, I'm sorry. I don't think that, I just told that may not have been published, and that's my fault. Let me go through that again. I apologize, just so the jury knows what we're talking about. May I publish it? None of these three, just to sum up, were associated with fully skeletonized remains, were they?
That's correct.
No further questions?
Redirect.
Based on what you do, these issues, the fact that there were, whether it's skeletonized remains or not, have no bearing on whether you would get DNA or not, correct? An item is an item.
Yeah, if there's DNA in an item...
like, for example, these panties, you're not testing the skeletons, you're testing the item.
Correct.
Okay. Just like duct tape is an item.
Yes, correct.
The fact that the remains are skeletonized have no bearing on the item, do they?
Well, of course, it can give problems, but the item itself, it can be investigated. So, and then the condition of the item is more important than the skeletonization of the body. So, the condition of the item, of course, is important.
And Mr. Ashton's three scenarios also leave out a fourth important scenario, do they not? Number 4 could also be that this duct tape was not wrapped around Kaylee's mouth. Isn't that not true?
That's correct.
And in fact, based on what you've testified already, you would have likely seen some DNA based on the scenario that the state presents, does it not?
Well, if there was DNA, if the tape plays over the nose and mouth, and especially the mouth and the mucosa from the nose, then there would be, at least at the beginning, there would be DNA.
And Mr. Ashton asked you about contamination and how sensitive DNA is now. When you find the perpetrator's DNA on an item, and you've testified in your experience that DNA profile matches the perpetrator or the suspect.
The suspect and
yes.
Later convicted persons.
You have never gone into court and said, you just can't ever know.
In what sense?
Well, Mr. Ashton was questioning you about, you just can't ever know if someone's DNA is on an item relates to the crime.
Well, the final decision whether it's crime related is in our system up to the judge and this system to the jury, of course. So no, we would never go further than there's support for hypothesis this DNA came from this person, and on an activity level, so it could be transferred. There's support for the hypothesis it is transferred during the crime or during pulling down the panties, for instance. So that's where we would go with this evidence.
Right. The evidence is either there or it's not. You don't give any interpretations and say things like, you just can't ever know.
No, it's on a crime level, yeah, it does match or doesn't match, or it would support a certain hypothesis or it wouldn't support a hypothesis.
There's DNA there or it's not. Correct? I'm speaking generally, I'm not.
Yeah. Well, if you have alleles, there's DNA, and if you don't, then there's no.
No further questions.
Are you telling this jury that the proximity of tape to rotting flesh does not increase the likelihood that the DNA on the tape would decompose as well?
It depends, of course. If the tape was on the body, which is decomposing, that would increase the chance that the DNA on the tape would also decompose.
No further questions. Thank you. Oh, I'm sorry. I thought you were done. Apologize. Go ahead.
Of course, it's depending if it's not on the body or it's a little bit away from that, then of course the chance of degradation of DNA is smaller. Of course, the outside conditions are still bad for DNA. On the other hand, of course, we have the PCR methods, which is so sensitive. We only need a couple of cells to obtain alleles or profiles.
So it does make a difference if the tape or item is in contact with decomposing flesh. It does make a difference, doesn't it?
Yeah, in my opinion, it does.
No further questions.
Yeah. Okay, may the doctor be excused for today. Thank you, doctor. You may stand down.
Just to clarify, he's not a doctor.
Well, whatever he is.
Thank you.
The defense may call their next witness.
Defense calls Yuri Melich.
Please stand, raise your right hand, and say out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please raise your hand.
My name is Yuri Melich, Y-U-R-I-M-E-L-I-C-H.
Good afternoon, sir.
Good afternoon, sir.
You are the lead detective in this case.
Correct.
Okay. And as part of your job as lead detective in this case, you have executed several search warrants of the Anthony home.
Yes.
Okay. And the first one was in August?
I believe so, yes.
Okay. And at the time that you did the search in August, did you find any papers dealing with chloroform in the home?
I don't recall finding any papers in the home, no.
No printouts from how to make it or any instructions on anything having to do with chloroform?
No, sir, not at all.
Okay. Did you find any containers that at one time or another contained chloroform?
No, not at all.
Did you find any rags that at one time were used to that had chloroform on them?
No.
Did you find any products that were used to make chloroform?
No.
Okay. Did you find any receipts on purchases of chloroform?
No.
Did you find any chemistry kits of the kind that might have been used to make chloroform?
No.
Okay. You then executed a second search warrant in December, on December 11th of 2008, correct?
Yes.
And on that occasion, did you find any receipts of purchases of chloroform?
No.
Did you find any containers that may have contained chloroform?
No.
Any rags or any cloth material that might have contained chloroform?
No.
Any chemistry kits that might have contained chloroform or been used to create chloroform?
No.
Any of the other items that I previously mentioned?
No, sir.
Were you looking for that?
I'd have to check the search warrant to see what was listed as far as the scope of the warrant.
If
I believe...
If I showed you a copy of the warrant, would that assist you?
Yes, please.
May I approach the witness, Your Honor?
You may.
Thank you.
Where you're specifically looking at the search warrant of December 11th. Is that not correct, sir?
That is correct.
Take your time and look.
Yes, sir. And your question again?
The question is, did you look for any of these items?
Yes, in the search warrant we did.
Okay. Now I'm going to show you the third search warrant that you did on December 20th, 2008. May I approach the witness, Your Honor?
You may.
Thank you. So I believe this is still December 11th.
Oh.
December 20th is right behind it, stapled.
Oh, okay. Did you, on your search warrant of December 20th, the third time going in there, did you also look again for chloroform items and all of the items that I just finished running down?
No, sir. The scope of the search warrant didn't include anything to do with chloroform or items used to make chloroform.
Okay. And the reason for that would have been?
We already conducted the search for the chloroform products on December 11th.
Okay. And you don't think you would have missed anything on December 11th through when you went back in there on the 20th?
Not to say I wouldn't have missed anything. We just didn't include it in the scope of the December 20th search warrant.
And would that have been because you did such a thorough job on December 11th?
I wouldn't disagree. We had no reason to incorporate it in that December 20th search warrant. We'd already looked for it in December 11th.
Okay. But if you had happened to come across a chemistry kit, you certainly would have confiscated it or photographed it.
We would have done it legally and stopped it and gotten an addendum to the search warrant, yes.
Okay. Did you find any chloroform at any given time in the Anthony home throughout the entire time you've been investigating this case?
No.
I have no further questions. May I?
You may retrieve the items. Cross-examination.
Thank you, Your Honor. Good afternoon, Detective Mellon.
Good afternoon.
On August 8th, when that search warrant was done at the Anthony residence, you did not have any preliminary or other results from the Oak Ridge National Laboratory regarding high levels of chloroform on carpet samples in the trunk, correct?
That is correct.
Okay. When that information was provided to you and ultimately became public knowledge, that was closer to the end of August, beginning of September of 2008, correct?
Yes.
At that point in time, Ms. Anthony was out of jail and living at home?
I don't recall specifically the dates she was in and out of jail, but I would presume so, yes.
Okay. Was she not out of jail between August 22nd and October 14th, 2008?
Yes, I do believe so.
Thank you, Your Honor. I have nothing else.
Redirect as to those issues.
When someone is out on bail, that doesn't preclude you from getting a search warrant and searching their home, does it?
I can get a search warrant whenever I believe there's probable cause to have a search warrant issued. So I can get a search warrant anytime as an investigator I would believe it would be necessary. Does that answer your question?
Yes, sir. And you got the preliminary results from the Oak Ridge National Laboratory in late August, did you not?
Yes, that's correct.
And then you got the computer results shortly thereafter.
That's correct.
Okay. Tell the ladies and gentlemen of the jury, after you got that information, how soon you went in to get another search warrant.
After getting that information, the next search warrant would have been on December 11th of 2008.
Okay. So you waited how many months?
From the time in August to December 11th. So it would be September, October, November, and into December.
And you didn't think that evidence was significant enough for you to get a search warrant to go look for those items, did you?
Not necessarily. It was obviously very significant, but as to just using that to get a search warrant for the house, no, I did not do that. That's obvious.
Okay. And when you finally did search the home, both times, you never saw anything of the kind.
Now, may I also address your previous question?
Sure.
Also, at the time in August, we were still looking for a live child as well. So even though we had these indications of chloroform in the trunk and in the computer, we were still looking for a live child. So
when Casey was first arrested, that was the day after, it was July 16, 2008, right?
Correct.
Okay. And then on October 14th, she was then arrested again for more serious charges, correct?
Yes, sir. After October 14th, we were no longer looking for a live child.
And you were no longer on October 14th because you had charged her with murder, looking
Correct.
for a live child, right?
Yes, sir.
Okay. So October 14th, November 14th, December 1st, all those times, you never went in there with a search warrant to look for these items.
Until December 11th. That's correct.
Okay. No further questions.
May the detective be excused.
Yes, no recall.
Okay, thank you, Detective.
Am I excused or subject?
Well, Mr. Baez says subject to recall, so you're excused for the day.
Thank you.
You're welcome, sir. The defense may call the next witness.
Yes, sir. The defense calls Dr. Marcus Weiss.
This way, sir.
Raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I'm Marcus Bain Wise, Marcus Bain Wisc.
Good afternoon, sir. Can you see me over there?
Yes, sir.
All right.
Good afternoon.
Can you tell the ladies and gentlemen of the jury what your occupation is?
I'm a research scientist at Oak Ridge National Laboratory. My specialty is analytical chemistry, and particularly the development of analytical methods in field analytical instrumentation.
Okay. And can you tell us, sir, your educational background?
I have a PhD in analytical chemistry from Purdue University, chemistry degrees and master's degrees from Furman University.
Okay. And do you have any additional training in the areas of analytical chemistry?
That is primarily my education, plus my on-the-job training over many years.
Okay. And how long have you worked for the Oak Ridge National Laboratories?
I've been at Oak Ridge National Laboratory almost 27 years.
Okay. And did you start that job right out of school?
Yes, I did.
Okay, well, that eliminates your job history. And do you belong to any specific types of organizations?
Yes, I do.
Which ones?
I belong to the Boy Scouts of America.
Professional organizations?
I do not at this particular time.
Okay. And have you ever published any articles on chemistry or analytical chemistry?
Yes, I have.
Okay. How many times?
I don't know the number right off the top of my head.
Okay. Can you give us a ballpark?
Oh, probably 15 to 20.
And have you lectured on the topic of analytical chemistry?
Yes, I have.
And have you given any presentations in that area?
Yes, I have.
Okay. And what about any awards? Have you received any awards in that area?
Yes, I have. I've won some awards in the past.
Okay. Is this the first time you've ever testified in court?
Yes, it is.
Okay. Judge, at this time, I would move to enter Dr. Weiss as an expert in analytical chemistry.
Absolutely no objection, Judge.
Ladies and gentlemen of the jury, Dr. Weiss will be accepted as an expert witness in the field of analytical chemistry. You may continue.
Thank you, sir. Now, sir, you mentioned you are a research scientist.
Yes, sir.
Okay. And what exactly does that mean?
A research scientist works on challenging scientific problems that need to be addressed and solved in order to push the frontiers of science to the next level.
Okay. What's the difference between a research scientist and a forensic scientist?
A forensic scientist can be a research scientist. Forensic scientist does a lot of research, oftentimes in the area of forensics.
Okay. And when you say when we say forensics, we're referring to utilizing science in the courtroom, correct?
That's correct.
Okay. And the Oak Ridge National Laboratories, that is a research lab, is it not?
It is a research laboratory, that's correct.
Okay. And what is the difference between a research laboratory versus a forensic laboratory?
A research laboratory works on very challenging scientific problems. We can develop techniques for forensics, pushing the frontiers of science and technology for forensics. We do not typically run routine forensic samples according to same protocol necessarily that a forensics laboratory would do.
So is it fair to say that you're not used to handling items of evidence, whereas in a forensic science lab, that is commonplace?
Overruled.
Evidence type samples are not as common in the kinds of work we do.
Okay. And in a forensic lab, another difference between the labs, or let me ask it this way, is the other difference in the labs protocols that are usually in place in a forensic lab that is not in a research lab?
I'm not sure the basis of knowledge has been established that he's ever worked in a forensic lab and would be aware of that.
Objection sustained. Establish a foundation.
Yes, sir. As a scientist, you're aware of different types of laboratories, are you not?
Yes, I am.
Okay. And you're somewhat familiar of their practices, are you not?
Somewhat, yes.
Okay. And one of the things that you're aware of in a forensic lab is that they usually have much more rigid standards as it relates to protocols.
Objection, foundation, and hearsay. If I could approach, I could explain more. But
I think the witnesses testified already as to foundation, and if it's within his area of knowledge, he can certainly testify to that.
Objection overruled as to the last question, if the witness can answer the question.
I have not worked personally in a forensics laboratory.
But you're aware that they have much more rigid standards because the evidence that they handle may someday end up in court.
objection, foundation, and leading.
Sustained as to leading.
Are you aware, sir, as to whether their protocols are much more rigid than a forensic lab? Than a research lab, excuse me.
I have not run forensic protocols, so I don't know just how detailed they are.
Okay. Now, in a research laboratory, you do not have rigid protocols, correct?
Much of the time when we're doing research and development, we are working according to protocols and methods that can be varied according to the needs of a particular analytical problem that arises.
And you are not concerned necessarily with protocols, and what I mean by protocols, that's written steps of what must be done in each and every case, correct?
There are methods that we use routinely that are not written. We do it all the time. It's like driving a car. We do it as a routine part of our job, day in, day out, year after year.
You just do them. You don't necessarily have to fill out any reports or anything like that.
That is correct.
Okay. And you do not have what are known as proficiency examinations, correct?
We do not conduct proficiency examinations for forensic samples, no.
And as well as what is called quality control.
We will, in these cases, are not running a routine procedure. That is correct.
And part of the reason for all of these types of standards is to prevent, of course, contamination. You're aware of that, are you not?
Leading and foundation.
Sustain.
Are there any protocols in place in your laboratory to prevent contamination?
We run blank standards samples to see if the instrument has a large background of contaminants in it.
But that's for the actual instrument itself, correct?
Yes.
You have nothing in place for an item before it actually reaches that instrument, correct?
Overruled.
And what are you referring to? Can you clarify that, please?
Sure. If you have an item that you're going to test, there are no protocols or quality control measures in place that would prevent contamination prior to you reaching the instrument.
And how do you mean that? I still don't really quite understand what you're saying.
Well, that's what I'm asking you. Do you have any quality control practices and procedures in place that would prevent any type of contamination in your research lab before it actually reaches the machine for testing?
And how would it become contaminated? I still don't quite understand what you're trying to lead to here.
All right. Well, let me rephrase that then. Are you aware of any methods of contamination for your laboratory?
No, I'm not.
And that's because as a research scientist, you are expanding the boundaries of science. Is that not correct?
Objection. Leading.
Sustained.
As a research scientist, is it your job to expand the boundaries of science?
Yes, it is.
Okay. And that is your primary focus and goal, correct?
That is correct, yes.
Not necessarily to be alert or to be worried or concerned about contamination of items of evidence.
As an analytical chemist, I am typically aware of major sources of contamination that could occur, which would be...
And where you realize that is when you actually test the item, correct?
Sustained.
Is there anything that you have in place in your laboratory that would be able to alert you to contamination other than when you actually reach your instruments?
We do not have a background monitor of sorts, no.
Okay. Now, you were given items to test in this case, were you not?
Yes, I was.
I'm sorry?
Yes, I was given items.
Okay. And how were you initially asked to test these items?
I was asked to run those samples by gas chromatography, mass spectrometry to perform a qualitative analysis to determine what was in them.
Okay. Now, how were you asked to do this? Somebody called you on the phone? How did it happen?
Dr. Arpad Vast requested that.
Okay. Did he come to your lab?
He talked to me somewhere, and
okay.
His office is near mine.
Okay. And where did you get these items from?
They were in his office.
Okay. And he was not there that day, was he?
I believe that's correct, yes.
Okay. So was his door open?
He left me a key to get into his office.
Okay. He trusts you. So you opened the key in his office, and where did you find these items of evidence?
I don't recall exactly where they were in his office.
Okay. They're not on his desk?
They were on a desk or a file cabinet or somewhere. I don't recall exactly. It's been a while.
Okay. What container were they in?
I don't recall what kind of shipping containers they were in. One of them was a bag with a gas standard or a gas sample. The other was a metal can.
Okay. And then you took this item to your laboratory?
That's correct.
Okay. And when you got to your laboratory, you ran a test using an instrument, correct?
That's correct.
And this is the gas chromatograph mass spectrometer?
That is correct.
Okay. Now, you had no idea or no knowledge of the prior history of that item, correct?
No, I did not.
Okay. And you just mentioned that you ran what is called a qualitative analysis. What does that mean?
Qualitative analysis tells you what constituents are in the sample.
Okay. And does it tell you how much?
A qualitative analysis is not a quantitative analysis, which by definition tells you how much is there.
Okay. And when you were initially asked to do these things, did you advise Arpad Vast that a quantitative analysis would not mean anything in this case?
Objection to the question, do these things, without specifying what things he's referring to.
And what's the objection?
The objection is the question is vague in reference to these things.
Vague, sustained.
Okay. The item that you were asked to test, sir, in fact, all of the items that you were asked to test in this case, did you advise Dr. Vast that a quantitative analysis, which means how much, would not mean anything in this case?
He asked me to conduct a qualitative analysis, which was the first thing that was done. At that point in time, we did not talk about quantitative analysis.
Okay. At a later point in time, well, let me take it step by step. So then you got a result, correct?
That is correct.
And the result that you received showed a high peak?
It showed a peak that was significantly above the baseline of the response of the instrument.
And the readout is called a chromatogram, right?
Yes, it's called a total ion mass chromatogram.
Okay. And what that tells you is, it tells you the peak versus what the next chemical is compared to how, let me rephrase that. That's a poorly asked question. It gives you a peak and then shows you the next peak and tells you, I guess, shows you the difference between what's there, what the different chemicals are there, correct?
Objection leading.
Tell us what a chromatogram shows.
A total ion mass chromatogram shows a series of peaks, can be as little as one peak or no peaks if there's nothing in the sample, but oftentimes there are several peaks there. The approximate relative height of those peaks is an approximate indication of the relative abundance of those compounds in that sample.
And it does not tell you how much of that item is there. It just shows you a comparison from one chemical to the other, right?
That is correct, yes. It's not a quantitative analysis.
Okay. And after doing this examination, you advised Dr. Voss that a quantitative analysis would not mean anything in this case, given the scenario, correct?
We actually performed a second test before that decision was reached, yes.
Okay. And that decision was made by you because you're the chemist.
To not do a quantitative? What decision are we talking about?
To not do a quantitative analysis because it wouldn't mean anything.
That was my advice, yes.
Okay. And was there ever done a quantitative analysis in this case to determine how much chloroform was there in those samples?
Okay, so in the sample where we found chloroform, it was not quantified in any of the samples because that would have been a meaningless number.
Okay. And it would have been meaningless because a trunk is a free-flowing environment, correct?
Objection leading.
Sustained.
Why would it have been a meaningless exercise?
A quantitative analysis of chloroform, let me explain. Chloroform is what is called a volatile chemical. That means that it evaporates easily. A good example of a volatile chemical is gasoline. And for example, if you pump some gasoline and you get a little drop of gasoline on your finger, you can see it and it smells very strongly of the gasoline odor. After a few minutes, that odor begins to decrease, and then after about 10 or 20 minutes, you can't smell it anymore. The reason for that is that liquid has vaporized. The molecules have moved from that surface of your fingers into the atmosphere and they're swept away. So the concentration on that surface is continually decreasing over a period of time to the point where you can no longer detect it, in this case, with your nose. Chloroform is that type of a compound. It's a volatile compound. And so if you put a drop of chloroform on a surface, starting off when you first put it on there, it's going to begin to evaporate, and over a period of minutes, hours, days, it's going to decrease. The rate at which that concentration on the surface decreases depends on a number of factors. One is the temperature that the surface is exposed to. The chemical nature of the surface is important. That will affect the rate that it evaporates. Whether or not the surface is exposed to flowing air or if it's closed up, all of those factors that are going to affect how quickly that concentration decreases.
Let me stop you there. And if a trunk is closed, that would prevent that would slow down the volatility of the chloroform, would it not?
It won't slow the volatility, but it may not escape from the air in the trunk as easily.
Okay.
So there are a number of factors. In this case, if we had made a quantitative analysis of the amount of chloroform on the sample that we had, which was a small piece of carpet, we would have come up with a number that said there's X number of micrograms, for example, of chloroform on that piece of carpet, which is the amount on that piece of carpet at a particular snapshot in time. That little piece of carpet does not reflect the entire piece of carpet that was in this vehicle, and is only a small little piece of that puzzle as well. So if we made a quantitative measurement on that little piece of carpet at the time that we received it in our laboratory, the amount that would be on that surface would be somewhat lower. It could be a little bit less. It could be a whole lot less than what was originally there. So the amount on the original carpet when it was first exposed to chloroform could have been twice as much, 5, 10 times, 100 times, 1,000 times greater. And we don't have the pieces of the puzzle in order to back calculate from a quantitative measurement to what we really want to know, which is the amount that was there in the very first place when it was first exposed to the chloroform.
And because you don't have the history, you didn't even bother checking as to how much was there. Because it is the reason you didn't check because you didn't know the history.
Did not know the history. You would have to know the temperature in that trunk over a period of time, how it varied every single day. You would have to know when the material was deposited there, because it's been evaporating however many days it first got there. It's been going down. So if it was there for 1 day versus 30 days, the amount that was there originally could have been considerably higher. An example that was 30 days old versus one that was 1 day old.
And because there are so many unknowns, you did not ever come out with an amount of chloroform?
No, I did not, because if I had said that on this sample it contained a certain concentration of chloroform that would have been set in stone from that point on as being the exact concentration of chloroform in the trunk of that vehicle, and that number would have been totally meaningless because it cannot be relayed back to what was truly there at the very beginning.
Okay. Now, when you did these tests, you were given air samples from the trunk of the car, correct?
There was a gas bag sample, which is a little plastic bag that are sometimes used to collect a sample of air for chemical analysis.
And when you tested that air, there was virtually nothing there?
There was virtually nothing there, but my experience with many gas sampling bags is that the chemicals that you put into those tend to diffuse out over a period of a few days, and they're not good anymore. So it's not surprising that a gas sample bag did not show the presence of chloroform.
That's not surprising, but certainly you don't know what was in the air of the trunk of that car.
And I don't know what was in the vapor in that trunk.
Correct.
From what we measured, the piece of carpet that we had was a point source. That was where chloroform appeared to be coming from based on the analyses that we did.
Now let's start right there. You took the carpet and then you actually put it in a Tedlar bag, is that correct?
The very first analysis that was performed is we got a metal can that was sent to us that had the carpet sample in it. And the analysis I did while Dr. Vass was out of town was to barely crack the lid on that metal can, put a syringe in there, and pull a small sample of the gas out and inject it into my gas chromatograph mass spectrometer.
Okay.
That showed us that there was some chloroform there as the largest peak in that chromatogram.
And subsequent to that, you heated up the actual sample.
Okay. What we did after that, I talked with Dr. Vass, and I told him what I saw. I told him that the largest peak in the chromatogram was chloroform, and there were some other peaks in the chromatogram that were lower in abundance, and that in order to see those more clearly with our analytical instrumentation, we needed to concentrate the sample a little bit so that we could amplify the signal on the gas chromatograph mass spectrometer. So what we did...
Let me stop you there, sir, so we can answer my question.
To the witness being interrupted.
He's being non-responsive.
Sir,
Did you finish answering the question?
Thank you, sir. Where was I? Let's see. We got the sample. We ran the sample from the can. We saw something. The chloroform and other constituents that we saw from that can sample was vapor that was inside that can. Okay. Couldn't say for sure where it was coming from, but it was a vapor that was in that can. Now, to establish where that vapor came from.
At this time, he's being non-responsive to my question. I'd like for him to answer my question. Okay. Go right ahead.
In order to determine where the constituents came from, we took that carpet sample from the can, out of the vapor that it was in, put it in a clean gas sampling bag by itself, so the vapor is left behind, and we injected some clean air into that bag. That bag was then put into an incubator, which was held at, I believe, 35 degrees centigrade for 2 days. 35 degrees centigrade is about 95 degrees Fahrenheit, I believe. So it would be similar to a hot summer day here in Florida. After 2 days, a sample of that air was removed that was inside the bag and then analyzed subsequently by the gas chromatograph mass spectrometer, in which again we saw chloroform as the major peak, the largest peak in the chromatogram, and we saw other peaks in there as well.
Are you finished, sir?
Yes, sir. Thank you.
Okay. Now, the gas chromatograph mass spectrometer is a highly sensitive instrument, is it not?
It certainly can be, yes.
Okay. And in fact, I can give you a drop of water and you can tell me all of the different chemicals that are in there.
Down to a certain concentration level. I run my instrument so that the sensitivity for about 1 milliliter of air is in the low parts per million concentration range in air. So we can see constituents that are present at a level of, say, 2 parts out of 1 million parts of air.
And there were standards of chloroform purchased for this case, were there not?
Yes, there were.
Okay. And you did not use those standards to help measure how much chloroform was there, correct?
That's correct. As I've already stated, we did not do a quantitative analysis for the exact reasons that I told you. A quantitative analysis would have been meaningless. It would not have made any sense to assign an absolute number to the amount of chloroform that was there.
Okay. Can you tell the ladies and gentlemen of the jury what you used the standards for?
The standards, when we run a gas chromatograph mass spectrometer, what we get is a series of peaks. Those peaks correspond to the amount of time that it takes for a particular chemical compound to move through a very long, thin glass tube that's inside the gas chromatograph and get to the other end. The amount of time that it takes to get from one end of the glass tube to the other end is dependent on the particular type of molecule. So chloroform, for example, takes about 16 minutes to move through that column to the end where the detector is, which is a mass spectrometer. And so when we run the instrument initially, we look at that peak. We find a peak that occurs, in this case, at 16 minutes, and we, with the help of our computer, take that peak and we can examine what is called the mass spectrum underneath that, which helps to identify the nature or identity of that particular compound. And we can do what is called a library search or a library match that takes that mass spectrum and says it looks very similar to this compound or that compound. That's called a tentative identification. In order to confirm the identification of that compound, we buy an authentic sample of that chemical. We inject it into the mass spectrometer, determine if the time that it takes to go through the column is the same as we found for our tentatively identified compound, and that the spectrum matches that. So it's a way to take something that we know the confirmed identity of and match it to the experimental data that we got.
So to be crystal clear, the standard was not used in any way, shape, or form to attempt to determine how much chloroform was on these samples?
It was not intended to do that.
Okay. I'd like to now show you Defense Exhibit CJ composite. May I approach the witness?
You may.
I may need a microphone. Can everyone hear me okay? All right. Do you recognize those notes?
Yes, I do.
Okay, and are they handwritten notes of what you're doing in the laboratory?
Yes, they are.
Okay. I'd like to refer you to the first page, page 72. No, 72. I'm looking at these pages.
Yes,
okay. You indicate here, while you're testing the triple sorbent traps, that the system blank was reasonably clean. Is that correct?
Right. That's just a note to me. It's just to let me know what I think about the blank in the system.
Okay. And because you're a research laboratory, you don't have any standard protocols that say they must be absolutely clean.
In this case, that was not the objective, no.
Okay. In fact, you look at it and you said it's reasonably clean.
Yes.
Okay. But there's no standard for you to determine that, and that wasn't your primary
No, it was
goal.
not the objective in these. That's correct.
And then on page 73, you indicate that there is a very large benzene peak from the trip blank.
Yes.
What's the trip blank?
A trip blank is a triple sorbent trap that goes with the sample to the site and comes back. And if it's compromised in any way, then there could be something on that.
Okay. And does that very large benzene peak give you any indication as to whether it's compromised or not?
It would suggest.
Could I object to relevance? Just ask counsel to specify which item in evidence this is an examination of.
Yes, sir.
Mr. Baez, rephrase the question so counsel would know what item you're talking about.
Yes. What item are we talking about in this as that you have indicated there?
It is a trip blank from a triple sorbent trap.
Okay. Of which item?
The file name was OCSOTB01.
Okay. And would that have been one of the from one of the carpet samples?
No.
Okay. Would that have been from one of the air samples?
It would have been an air sample collected somewhere down here.
Okay. Now, the items that have what is the significance of a very large benzene peak in a trip blank?
It suggests that benzene contamination has gotten into it.
Okay. You don't know how that got there?
No, I don't.
Okay. All you noticed is that you picked up on it in the middle of your testing?
Yes.
Okay. Now I'd like to refer you to page 74, where you're still discussing the triple sorbent traps. Can you put an asterisk there? What are you trying to indicate there? I can barely read it there.
Okay. I've asterisked the fact that triple sorbent trap can absorb some water, and in order to avoid having that water plug the system up, try to purge it off.
Okay. And was that a surprise to you?
No, it's not. That happens frequently with triple sorbent traps.
Okay, and that's the reason why you indicate that there?
Yes.
Okay. Now, on the following page, you put that the trap froze. What does that
Yes.
mean?
approach?
Yeah. Okay, members of the jury, we're going to take a stretch break to 20 minutes till hour, about 7-minute stretch break. Okay? You may be seated.
Almost there, Judge.
Okay.
This is
Okay, let's return to jury. You may be seated. State recognized president of jury. Defense.
Yes, sir, we do.
You may continue.
May I approach the witness?
You may.
Hey, Dr. Weiss, the items that you have, I'm now showing you page 74, where you put an asterisk next to that.
Yes.
That portion of your notes. What do you write there?
I'm writing that I'm trying to purge the water off the trap. I think it's important for the jury to understand what water in the trap is all about.
I understand. Go ahead.
Okay,
Explain.
I may explain that. A triple absorbent trap is a little 3-inch long stainless steel tube about 1/4 inch in diameter that is packed with a material that is similar to activated carbon. And in very simple terms, it is a chemical sponge that soaks constituents up out of the air so they can be concentrated and then taken out of that sponge and injected into the gas chromatograph mass spectrometer. The way that's done is heating that trap up, which vaporizes the absorbed materials and drives them into the end of the gas chromatograph. There's a 2-step process there. One is to pass a lot of air over that trap, which allows the air to go through but causes the chemical constituents to stick to that chemical sponge. There's a lot of water in the atmosphere, particularly down here in the summertime in Florida, and so a little bit of that water vapor sticks to that chemical sponge. The second step in the process of analysis is to heat that chemical sponge up, the TST trap, drive the chemicals off of it, and to take those chemicals and pass them through a very short, narrow stainless steel loop that is immersed in liquid nitrogen. And so the chemicals are heated, they come off of that chemical sponge, the stainless steel trap that we're talking about, they vaporize, they pass into this little loop that has liquid nitrogen in it, and that freezes the chemicals right at the very beginning of that glass tube I was talking about, the gas chromatographic column.
I'm sorry, and this is related to State's Evidence 122, correct?
That's correct. What happens is that a little bit of that water, sometimes it vaporizes out of that TST trap, the sponge will get into that stainless steel loop, and over a period of a couple of minutes, very small ice crystals can form inside that loop and block the flow of air, in which case we have to warm that loop up just enough to melt the ice and to reestablish a flow of sample through.
Why are you writing that down?
Just to make sure that I know that it's there. If this were a quantitative standard or a sample, I'd be concerned that maybe some of the lighter chemicals that would boil at a low temperature could be lost from that trap and not be there in as great of abundance as they might otherwise have been.
So because this is a qualitative examination, your methods are a bit different.
In this case, it was not quantitative. I do want to make sure that we know that it did freeze. But let me also kind of give this analogy. It does not mean that the sample is not a qualitatively pretty good sample here. Okay. If you take a glass and put it on a table, fill it with ice and a cold drink, what happens is you see water condense on the outside of that glass. It's condensing the water from the atmosphere. That's kind of what's taking place inside the stainless steel loop. If you were to pour the water out of there and that glass warms up, the water doesn't all just go away immediately in the blink of an eye. It's still there. It takes some time for those chemicals to disappear. So they don't all disappear off of the trap or off of this stainless steel loop that we're using to trap them with liquid nitrogen.
And you, of course, had another chemist verify your work that it was being done correctly, right?
This is the way that we often encounter triple sorbent traps. It's not uncommon for them to freeze. A lot of samples have been run over the years that have been run in duplicates that indicate that there's not a huge difference qualitatively between samples that freeze and don't freeze.
My question, sir, is you, of course, had another chemist verify your work to see that it was done correctly. Yes, State's Evidence 122. It was announced into the record. 122. It was announced on the record.
Dr. Vass is aware of what was run here.
Okay. Is Dr. Vass a chemist?
Dr. Vass has many years of chemistry experience working through our group and establishing analytical methods, working with mass spectrometers, approximately a dozen years worth.
So Dr. Vass is a chemist?
He is a scientist with significant analytical chemistry experience, and he has also had extensive experience working with triple sorbent traps and this particular type of a method.
My question, sir, is Dr. Vass a chemist?
He is, if you consider on-the-job training and his experience. It is not his title, but he does have the experience.
And were you hired at the Oak Ridge National Laboratories based on on-the-job training, or did you have to go to school and get a PhD in chemistry before they hired you?
I was hired as a PhD chemist, but I also learned a lot on the job in cross-cut and actually am able to perform in other areas besides exactly what my PhD is in.
Okay. And are you aware of the last time Dr. Vass had a chemistry class was in the 1980s?
I could not tell you. I can tell you that he has worked extensively with me routinely over the past 12 years in an analytical chemistry laboratory, designing and building analytical instrumentation, running and validating analytical methods, helping to troubleshoot and repair instrumentation, helping to design and build new instrumentation.
The two of you are fairly close.
We are very close colleagues. Yes, we are.
Okay. And you've worked together for many years?
Yes, we have.
Sustained.
And you, of course, would not. Do you have anything negative to say about Dr. Voss?
He is very talented, very intelligent.
Okay. Now, I want to get back to my original question is, did you have another chemist verify your results?
No.
Now, on the item which refers to State's Evidence 117, you write that the trap froze up?
Yes.
Okay, at what point?
At 1 minute, 50 seconds into the run.
And what did you do when the trap froze?
So I had stated a minute ago, when a trap freezes, very small ice crystals form inside the stainless steel loop. We remove the cooling liquid, allow it to warm up just enough to reestablish a flow through that loop.
And you have to let it thaw out?
You have to warm it up just enough for the water to melt and for air to be reestablished, yes.
What does State's Exhibit 117 purport to be so the jury know what y'all talking about?
Yes, sir. The triple sorbent trap air sample from the trash found inside the vehicle. Now I'm referring you to page 76, where we're referring to State's Evidence 116. The sample froze up again, did it not?
That's correct.
Your Honor, could we specification which sample, what place that is, and the numbers are different?
116, sir, relates to the air sample from the passenger area of the car. Correct? Is that correct? If you want to look. What's this one?
Okay.
And now on page 79, you write that the system blank appeared to be clean. Is that correct?
Yes.
And that is for the standards, correct?
That's correct.
Now, on page 82, you write with two asterisks that you decided to abort this run. And
on evidence, unless it's impeachment of
Sustained.
some sort.
Are there any issues that you run into with this item? First, describe what it is you're doing and the issues that you have.
I was going to run a blank on the system, and after I started the run, I just noticed that I had not changed the computer program to set the conditions to where I wanted them, so I stopped it and I reset the conditions.
You caught yourself in the middle of an error.
I did, yes.
Okay. And because you're a research laboratory, you do not have standard protocols or a checklist that would prevent this from happening. You have to rely on your own self to catch your own errors.
Overruled, you can ask the question if you can.
I've already stated this was not run according to a numbered or lettered protocol. That's correct.
We understand that, but I just
Yes.
want to make sure. Okay. Now, on page 86, you have another asterisk there where you caught yourself in another error.
Objection.
Correct?
Counsel is reading from a document that's not in evidence.
Sustained.
Did you, were you working with standards? Can you describe what standards you were working with on page?
This was a standard to determine the retention time of a sample on the gas chromatograph.
Is this sample 116 again?
No, this is a standard. It's not an actual item. And did you catch yourself in an error there?
Yes, I did. I noticed that it did not appear to be as it should be.
Okay.
Yes.
And again, you do not have protocols that would prevent this. You have to rely on you catching yourself making errors.
I told you we did not run these according to a numbered or lettered standard method.
Okay. Did Dr. Voss catch you in this mistake, or did you catch yourself?
I caught these, yes.
Okay. Now, on 87, did you catch another error on the standards?
That was a continuation of the prior.
Oh, okay. And did you change something in the middle of your process?
This again was running a standard of a compound that smells really bad, and so yes, I changed the way it was injected to keep from smelling up my laboratory. Yes.
And because you don't have specific protocols, you have to adjust what it is that you're doing to get the desired results, correct?
Objection, leading.
Sustained, rephrase the question.
Yes, sir. Did you have to change your procedure in the middle of your examination?
I changed it voluntarily to keep from smelling my laboratory up, yes, but it does not affect the determination of what I needed to determine, which is the retention time and mass spectrum of that sample.
Okay. Now, on page 89, you expected to see something in one of the standards, but you did not, correct?
That's the same standard that I was just talking about. That does not smell good. It's sticky.
And what did you expect to see that you didn't find there?
I did not see it come through the gas chromatograph, which meant that it was being held up somewhere in the system or not being injected as it should have.
And you put asterisks and you put it in a special box because it was something that was somewhat of an error, correct?
Yes.
Something unexpected.
It's unexpected, and yes, I wanted to make sure it was corrected.
Did Dr. Voss catch that, or did you catch that?
I ran those standards, yes.
On page 90, did you make an adjustment because you didn't see certain things there?
This again is the same standard that smells bad. The idea was to get it into the instrument as cleanly and easily as possible to get the retention time and the mass spectrum of it.
Okay. You had to make adjustments in the middle of these runs.
But they're not adjustments that would affect the information that was to be obtained for that particular sample.
My question, sir, is you had to make adjustments in the middle of the run.
Objection, ask and answer.
Overruled, you can ask the question.
You had to make adjustments in the middle of the run.
I made adjustments voluntarily to the sample run, yes.
And that's because you did not see dimethyl trisulfide.
I could not see it under that prior conditions, yes.
You didn't see it where you expected to see it.
It would not go through the inlet because it's a heavy material and sticky.
So the answer to my question is yes.
Yes.
Okay. On page 93, was there an issue that messed up this run?
Yes, it's a closed valve.
Okay. And did you catch yourself in an error there?
Yes.
Do you know what item this is involved with?
This is involving the standard.
It's a retention time standard. It's the same one.
And on page 94, do you note that you continue to have problems?
Yes.
Okay. And was there any time during the process of inspecting these items that your instruments broke down?
I don't recall.
Okay. You don't recall, or is it possible that you had issue with your gas chromatograph mass spectrometer?
Objection calls for speculation and
Sustained.
I'll rephrase the question. Are you aware, sir, that your gas chromatograph mass spectrometer broke down while studying these samples?
objection asked and answered is in fact not in evidence.
Overruled.
You can answer.
It did not break down. No, there was looks like the loop on the front end during running that standard was dirty based on the prior experiments, which was troubleshooting and finding the source of that issue.
And you do not have any quality control methods that would prevent this from happening when you're actually working a forensic case, do you not?
Sustained.
Do you have any quality control standards that would prevent this from happening?
Objection. Same question, still leading.
It's not leading, Judge.
Sustained.
Do you have any quality control methods, sir?
In these cases, the quality control is to look at the sample and determine whether or not the retention time is the same for the authentic standard that is injected.
You are the quality control, essentially, are you not?
Objection. Leading. Can we approach, Your Honor?
No. Objection sustained.
Are you, sir, the only method of quality control in your laboratory as you run these types of samples?
I am a primary method of determining that the instrument is functioning correctly, yes.
Okay. And there are no other chemists that worked on this case other than yourself?
Myself and Dr. Vass ran the samples, that is correct.
Okay. Dr. Voss is not a chemist, right?
Dr. Vass is very qualified.
Okay. He's not a chemist, though, is he, sir?
That's not his written title.
Okay. Now, I'd like to direct your attention to did there ever come an occasion where you worked on a case where you issued standard protocols for the collection of volatile soil samples for analysis?
No, we did, yes.
Okay. May I approach the witness, Your Honor?
You may.
I'm now showing you, sir, Defense Composite CK. Do you recognize that document?
Yes.
And you authored that document?
Yes, I did.
Okay. And does this inform anyone who's collecting samples that they should avoid?
Objection. Reading from the document is not in evidence.
Sustained.
Do you, in these, have you ever issued protocols, sir, that suggest that samples should not be collected near areas of gasoline or any items like that, any volatile compounds?
This was for the collection of soil samples, yes.
Okay, so the answer is yes.
Yes.
A protocol for collection of soil samples to this case.
The results, if I can go one more step, Judge, I can connect the relevance.
Go ahead.
And the reason for this, sir, is because, if I can finish the question,
Let him
Judge.
finish the question, Mr. Ashton.
Okay. Is the reason that you have these protocols to prevent contamination and to prevent false readings.
Sustain.
Why, sir, do you have that protocol?
When collecting soil samples, the objective is to collect them in an area that is pristine as possible.
Okay. And is the reason for that is because you want to be able to determine what is actually there?
Sustain.
What's the reason for that, sir?
It is to avoid contamination whenever possible.
Okay. And can contamination come from gasoline?
Could we approach?
You may. You may continue.
Can you review that document and make sure that you familiarize yourself with it again?
Yes, this is a document for the collection of soil samples to test them at a later date for the presence of volatile organic compounds.
Do your protocols, sir, recommend that the collection location should be free of trash, debris, and obvious sources of chemicals that could result in false positive readings?
Objection. Relevance of soil sample collection protocols to this case.
I think the witness judge has...
Soil samples sustained.
Soil samples aside, sir, do you recommend that collection for samples should be free of trash, debris, and obvious sources of chemicals that could result in false positive readings?
It depends on what the objective.
What type of sample is counsel asking about? Water, air?
Any samples.
Sustained. Rephrase the question.
Sir, when running samples, regardless of the sample that you're running, do you recommend that the locations be free of trash, debris, and obvious sources of chemicals that can result in false positive readings?
It depends on the objective of the analysis. In some cases, the sample is part of a trash heap, and therefore it is necessary to collect it in the presence of whatever is there.
If you were collecting a carpet sample, would you recommend that it be free of trash, debris, and obvious sources of chemicals that could result in false positive readings?
Again, in some cases you have no choice as to where to collect a particular sample because it's where it is, and whatever else is there is part of that environment that it's in.
Do you recommend that an item that you're testing be separate and preferably apart from any other items?
Asked and answered.
Sustained.
I don't believe he's answered the question, Judge. Could a false positive reading come from trash, debris, and other source chemicals?
Objection. A false positive reading for what?
Sustained. Rephrase the question.
Yes, sir. Any items that you test, could you get a false positive reading for trash, debris, and other chemicals?
Same objection, Judge. A false positive reading for what?
I've made it a very general and broad question, Judge.
Sustained.
When running air samples, sir, do you recommend that trash and debris and obvious source of chemicals not be part of the sample?
Sometimes that's exactly what you want to monitor.
If you're not testing trash?
Sometimes you cannot separate the two. It depends on the objective of the analysis.
My question to you, sir, is if you're not testing trash and you're testing a specific item, do you recommend that it not be near any trash?
Sustained. We've asked this question numerous times in various fashions. Move on to another area.
Do you recommend, sir, that collected samples not be stored at locations that are contaminated with organic chemical vapors such as gasoline?
That is always a good thing to do, if at all possible.
Okay. You're aware, sir, that there was trash found in the vehicle that was tested, right?
I did not see the inside of the vehicle.
I didn't ask that. I asked you, sir, that you are aware that trash was found inside the trunk of the vehicle, correct?
I believe that is correct.
Okay. Now, being aware of that, do you know the location of where the trash was?
I do not have any idea whatsoever.
Okay. Did you request when collecting these samples that you get a non-stained portion of the trunk of the vehicle?
I did not request the samples at all.
Okay. Would a non-stained portion give you an identification as to whether your sample was coming from the stain or another non-stained area?
You need to rephrase that. I don't understand.
Okay. You tested a piece of carpet that was allegedly stained. Isn't that correct?
That I got a piece of carpet. I assume it was stained based on what I understand.
So did you say, if I want to compare this piece, we should compare it to a non-stained portion to be able to determine what's in that stain?
I, again, did not request the samples that were sent to me. I was requested to analyze samples that were given to me.
So the answer is a no?
I did not request the samples, or I made that clear.
Instead, what you decided to compare it to were stains from or carpet samples from completely different cars in a junkyard, did you not?
Objection leading.
Sustained.
What did you compare them to then, sir?
I did not decide what samples were to be collected or what the comparison should be.
I didn't ask you that, sir. I asked you what you compared it to.
There was a carpet sample collected from another vehicle, yes.
Okay. From a junkyard in Tennessee.
I do not know the exact location. I did not collect sample.
Are you not a co-author of the report in this case?
I was, yes.
And is it not a fact, sir, that you indicate in that report that these are carpet samples from a junkyard?
Objection leading.
Sustained.
Does the report, sir, indicate where these samples were collected from?
I don't have it in front of me, but...
Do you not recall?
I think it was from a car that was in a junkyard, yes.
Okay. So when you answered a moment ago, you didn't recall, but now you do?
You are asking me what?
Yeah, I asked you.
Was a sample from a junkyard? Is that the question?
The first time I asked you, sir, you said you do not recall where they were collected from.
I do not know the location of...
Can the witness be allowed to answer, please?
I was not finished with the question, sir. I was just instructing the witness.
Well, sir, finish answering the question.
I have no idea what yard, junkyard, or wreck card yard, or anything else the sample came from. I've never been there myself. I did not collect the sample.
My question to you, sir, is initially when I asked you where these samples were collected from, you said you had no idea where they were collected from. 30 seconds later, you recalled that they were from a junkyard. Did you not?
You said that they were, and they were from, I think it was listed as a junkyard, but I don't know where. I don't know where that junkyard is. I do not know the location of it.
Are you aware that it came from Tennessee?
I believe so, yes.
If I can have just one moment, Judge.
You may.
There was a addition, when you reviewed the report, sir, there was an addition that you chose to make, did you not?
Yes, I did.
And this was after reviewing what Arpad Voss had indicated in his report?
I don't know if it was after reviewing it or just a suggestion for the report.
And the suggestion that you wanted to add is that these chemicals that were found in these samples could also be associated with other types of materials.
Yes, and let me make it perfectly clear. In a mass chromatogram, if you take any one peak, there is nothing in the data that says where that particular compound came from. It says that it's there, but it doesn't say what the source was. And I cannot tell you the source of any single one particular compound that we've analyzed.
If I can have just a moment, Judge.
You may.
Sir, are you aware that air samples were taken 6 weeks after the carpet sample was sent to you?
Taken where? I don't know.
Okay. Are you aware that you later received air samples from the Forensic Bay garage?
What kind of air samples were these?
Samples of air, triple sorbent traps from the Forensic Bay?
No, we've talked about the triple sorbent traps, yes. We've already talked about
As
those.
well as the passenger area
Yes.
of the car?
Yes.
As well as the trunk of the car?
Yes.
As well as the trash that was found in the car?
Yes.
And you are aware that these samples were taken 6 weeks after the car liner was removed?
That's correct.
Okay.
I believe that's what I've been told anyway.
And you would agree that the air 6 weeks later, depending on the environment, would be significantly different than what it would have been previously?
Sustained.
Is the air the same? Would the air be the same in the Forensic Bay garage 6 weeks later?
I have no way of knowing that.
Would the fact that it has a garage door that opens and closes make a difference?
I have no way of knowing how the air has changed over a period of time.
Okay. And what about the trash? Do you think that the trash would still have the same air 6 weeks later?
I have no way of knowing what the changes, if any, are.
And in your experience, there's no way you can determine that?
Sustained, rephrase the question.
Is there any way of knowing that based on your experience, sir?
I have no way of knowing if and how much it has changed, no.
Now, I've shown you Defense Exhibit CJ, and you had a chance to review it, correct?
Which is?
May I approach?
You may.
Yes, okay.
And these are your notes?
Yes, they are.
Do they accurately reflect the notes that you took
Yes.
when you took them?
Yes.
Judge, unless there's any objection, I would move CJ into evidence.
Hearsay. It also appears to contain certain interlineations or highlightings by counsel and other notations. But
Objection sustained.
Judge, I can redact or submit another one that's not highlighted.
Objection sustained.
I have just one more moment. Judge.
You may.
I'm not the question.
Cross-examination.
Good afternoon.
Good afternoon.
You have had a great deal of experience in examining environmental air samples in various aspects of your work. Is that correct?
Yes, I have.
Did you work with Dr. Voss at some level in some of his research involving decomposition odor, at least at the later stages?
I have worked with him in collecting and analyzing samples, yes.
Give the jury a general variety of what kinds of air samples you've had occasion to examine over your career and what types of circumstances.
I've looked at air samples from soil, various surfaces, ambient air, just about every kind of environmental type of a sample and matrix you can think of.
Now, your initial analysis of the carpet in the can was simply to basically suck out a volume of air and run it unconcentrated into the gas chromatograph, correct?
Yes, sir, that is correct.
And upon doing that, the biggest peak you found was for chloroform.
That is correct. The abundant, the tallest peak in that total ion mass chromatogram was chloroform, which indicates it is a major, if not the major peak.
And while you cannot, you also saw peaks consistent with gasoline fumes.
We did in the samples, certainly the one that was concentrated. Yes, we did.
But the peak for chloroform was far greater than peaks for gasoline.
The relative abundance in the total ion mass chromatogram for the chloroform was greater than the peaks for, they would correspond potentially to gasoline vapors. Yes.
Now, you wouldn't have been surprised to have found evidence of gasoline vapors in the trunk of a car.
Absolutely not. I've analyzed many samples that have been collected in and around vehicles that have fuel or fuel exhaust vapors associated with them.
And the amount of chloroform you found even in this initial run surprised you.
The witness has already testified that this is not a quantitative analysis.
I don't believe that's
the relative abundance of the chloroform seemed very unusual to me because, number one, chloroform is a suspected cancer-causing agent. It's not something that you just normally find in a sample. You find it in particular types of samples, but not just usually sitting out in the open, or I would not expect to find it in the trunk of a vehicle, but I cannot say where it came from. I cannot tell you where any chemical came from based on the kind of analysis that I do.
And as counsel pointed out, while you didn't do a quantitative analysis to reveal exactly how much chloroform was there, but you were able to gain some information about relative abundance from the gas chromatograph.
That's correct.
And was it your opinion that it was somewhere in the low parts per million range?
This witness, again, has not given a quantitative amount. It's not an evidence. Assumes facts not an evidence.
Overrule, if you can answer the question.
Again, I hate to place a quantitative number on there because when I do that, then it becomes an absolute.
Sure.
It was detectable at levels. My instrument has a sensitivity threshold for approximately 1 milliliter of gas that's in the low part per million range. This was significantly above the baseline.
All right.
I do not want to quantify it beyond that.
All right. So just so the jury understands, your machine is set at sort of 1 part per million, and anything above that should register.
That's in a very crude sense.
In a very crude sense, and that's how we lawyers talk, in a very crude sense. All right. Now, when you ran the concentrated sample, did you find that the relative abundance of chloroform to other compounds was similar?
It looked very similar, yes.
Now, when you found the chloroform originally, did you attempt to do some research through sources that you would normally do as a chemist to determine whether that chloroform could have come from some car-related product that you might not have known?
The chloroform, when I first saw it, raised a question in my mind because I did not expect to see it there. When we concentrated the sample, it was, again, the most abundant peak. Dr. Vass and I, one evening, sat down together just contemplating why was it there. I did look at some material data safety sheets for some common car products, cleaners and brake type cleaners, just to see if there would be some evidence of why that might be chloroform in the back of the car. It was not an exhaustive study, though, to look at products. It's just solved my own personal curiosity as to where it might have come from.
So you just spent a couple hours looking things up to see if there was some common product.
If I had found something, I would have said, okay, this is maybe a good explanation. But again, I cannot say where it came from or why it was there.
Of course.
Okay.
But you weren't able to find any explanation for its possible existence through that research?
With that very limited
of course.
amount of work, and it's not exhaustive. Just let me make sure that you're clear on that.
I am. So you spent a couple hours just trying to think of something that it might be and look that up, but you obviously couldn't think of everything.
That is correct. It would be a long, drawn-out process to try to look up every single compound that was there.
All right. Now, is it generally accepted in the analytical chemistry community that certain polymers can sometimes trap volatiles?
Yes. What are you referring to exactly?
Well, I'm just saying, you said that the chloroform is a volatile, that it evaporates quickly.
Yes.
Are there certain substances that can sometimes trap it, such as polymers or what the carpet is made out of, anything like that?
Yes, absolutely. Almost every material that is made out of carbon-based molecules, which includes virtually all plastics, are able to interact with organic molecules that also have a carbon backbone, and they will tend to absorb or adhere to those molecules to some degree or another. Yes.
Now, you also said that the reason you didn't do the quantification was because whatever quantity of chloroform you had at that moment in time, you would never have enough information to relate it back precisely to what it was at an earlier point.
That is correct. I said that because of several reasons. One is only in a small section of the carpet. I don't know if the amount of chloroform is uniform or how it was spread over the entire carpet. I don't know the rate of evaporation. I don't know the temperature that it was exposed to. All of those affect the rate of evaporation, whether or not the trunk was opened or closed or how frequently that was occurring. So there's no way at all that I could have made a quantitative analysis in any way, shape, or form, related that accurately back to the true total amount of chloroform that initially was in that vehicle when it first was exposed to the substance.
So, in other words, that the piece of carpet you had could have been the most stained with chloroform or the least stained with chloroform. You have no way of knowing. That is correct.
There's absolutely no way to know. It's only one little piece of the puzzle. The rest of the puzzle was somewhere else.
And it could have been from a car that had been closed for its entire time, or it might have been open half the time, closed half the time. That all would have affected ultimately how much chloroform there was to begin with.
That is correct, and those are things that could not be, it'd be a total guess.
Could not be known.
It could not be known. And so I did not do the quantitative analysis, because if I did and said that just hypothetically 50 parts per billion of chloroform had been found in that, or parts per million of chloroform had been found in that sample, it would have been extrapolated to be the exact concentration that was there, and that would be absolutely, totally incorrect.
Okay. Now, you would be of the opinion, though, that whatever amount of chloroform was there, it would have been greater in the past. In other words, chloroform doesn't increase over time, it decreases.
Yes, and we demonstrated that when we took the carpet out of the can and put it into a bag with clean air, because chloroform appeared in the air that was in that clean bag, and the only place it could have come from was chloroform evaporating off of that little piece of carpet sample.
That was the next thing I was going to ask you. Based on the way you performed this analysis, it was clear that the substance was actually in the carpet.
It was associated with the carpet some way, either in the carpet or something that was spilled on the carpet, but associated with that little piece of carpet.
The point of taking it out of the can was to separate the carpet from the air around the carpet, which might have reflected air around the carpet in the trunk.
That is correct.
Does that make any sense what I just said?
Yes, that is correct.
So what you were testing both for chloroform and for the other compounds that Dr. Voss found were things that were coming directly from the carpet.
That is correct, yes.
Counsel asked you about a notation where you said about an air blank being, what was the word? I don't know if it was mostly clean or quite clean, some word, some modifier like that.
Yes.
When you're running a trip blank, an air blank, are you running just room air?
Usually run room air, yes. Okay.
And is that a standard procedure in chemistry to run a blank with room air, whatever's just sort of there?
I do, because it just checks to see what's in my room.
Okay.
Okay.
And is any air in any room completely devoid of compounds?
No.
So any air from any place is not completely clean. It can't.
If you look hard enough, you're going to find something in just about every air sample. That is correct.
The various issues that were noted in your lab notes, the reason you put them in your lab notes is to make sure that you have a complete record of anything that was in any way out of the ordinary in the running of the test, correct?
Yes, that's correct. That it's my responsibility to do that.
That's so that other people can know exactly what happened.
That's right. And when it comes down to ultimately working up and developing a standard written procedure, we know the types of things that need to be avoided or considered in the procedural steps.
When you're inventing a protocol for other laboratories to use, you want to know to tell them, well, this might be a problem to look out for, that might be a problem to look out for.
Yes, that's absolutely correct. Yes.
Was there anything that occurred in the running of any of these samples that was extraordinary or extraordinarily out of order?
No, I did forget to close a couple of valves, but I did notice that the instrument did not function quite right. To me, my analytical instruments are my car that I drive. You know that when you drive a car and have a flat tire, you notice it right away. My analytical instruments, when something goes wrong, I notice that and very quickly can correct it.
Now, the purpose in obtaining control samples from the garage or the passenger area of the car or the garbage is to try to determine if any of those samples might have contributed to what you found in the trunk carpet.
And that is correct, yes.
And the fact that it was 6 weeks later, it was the best you could get.
That's correct, yes. If
it was. I mean, you can't go back in time in a time machine and grab a sample from...
Both of you can't talk at the same time?
You can't go back in time and grab a sample from a time 3 weeks before you needed it.
That's correct, yes,
You've got to take it from when you can get it.
Yes, sir.
Mr. Bias has asked you at length about Dr. Voss and his qualifications. How long have you worked with Dr. Voss in doing studies related to chemistry?
Probably 12 or 13 years now.
Now, in the Oak Ridge National Laboratory, are you each simply limited to your own specialty, or do you work together and sort of move into each other's areas?
A national laboratory is a national resource of scientists that interact together all the time so that we can take advantage of each other's specialties and expertise and learn from one another to broaden our horizons.
Has Dr. Voss worked on projects with you that had nothing to do with anthropology?
Yes, absolutely.
That had nothing to do with dead bodies or his area of specialty?
Absolutely. He's been a major contributor to projects involving the development of mass spectrometers, the validation of the performance of those instruments with standard samples, with the development of protocols for the analysis of biological samples. And one of the things that I really enjoy about Dr. Voss is his eagerness to continually learn. One of the things he says to me on a regular basis is, Mark, teach me what you know. Because when I do something and he says, wow, all the time, wow, how did you know how to do that? And so he comes in, he wants to work with me and learn not just from me, but from other people that we have in our group and other locations around the laboratory.
And has that been his continuing method of learning over the last 16 years? I think you said you've worked with him.
It's
sustained. We've covered that enough.
All right. No further questions.
Redirect?
Just briefly, Judge. Mr. Ashton asked you about the different projects that you've worked with Dr. Voss. One of those projects is the Labrador, is it not?
That is correct, yes.
And that's that handheld sniffer machine that is currently patented.
It's not patented yet.
Okay. And the application for the patent, you are also one of the beneficiaries of that patent, are you?
I am a co-inventor, but not really a beneficiary.
You would stand to earn royalties if that machine is validated and sold across the country, would you not, sir?
All scientists at Oak Ridge National Laboratory are required to report any inventions. Most of those patents, including Labrador, end up being assigned to the company, and only a minimal royalty would be received from that if it were ultimately sold to non-government users.
So the answer is yes?
Absolutely minimal.
Yes?
Minimal. Yes, minimal.
Okay. I'll take that.
Okay.
Sir, so this project that you had, all the work you did in this, you billed it to the Labrador project, did you not?
Every field analytical instrument requires the analysis of field samples in order to determine what kind of constituents are present in the kind of environment that instrument will be operated in. If you don't know that ahead of time, you end up building an instrument that will not function in the presence of interferences that are present in the real world. So running field samples such as this are very valuable for a project such as Labrador.
I don't know if you understood my question. My question was, sir, that you billed the work you did to the Labrador project.
I don't know for certain. I was working on the Labrador at that time. These samples are certainly consistent with the scope of that work.
So is that a yes?
I do not know for certain. I work on multiple projects.
Okay. Do you believe that the work that you billed this out to was the Labrador project?
It is very likely, and it certainly fits within the scope of that project, yes.
And as a research scientist, you have to earn grants, do you not?
Objection, leading. This is correct.
Sustain, rephrase your question.
What are some of the requirements that you have as it relates to generating income for the laboratory?
We write proposals to develop technologies in the case of the Labrador, yes.
And this is so you can get grants of money from the government and other sources?
They are funded research projects, yes.
And one of the research projects is the Labrador project?
That is a research project, yes.
Okay. And as your job, it's a requirement that you generate funds, correct?
Yes, it is.
Otherwise, your position may be eliminated.
And certainly all of us who are researchers have a requirement to seek research funding. That is correct.
And if your technology is validated in a court of law, that makes this Labrador a lot easier to sell, does it not, sir?
Objection assumes a fact, not an evidence, that this has anything to do with Labrador technology.
Sustain.
The Labrador technology is based on the work of Dr. Voss, is it not?
Labrador was an instrument I designed the electronics for in the sensing head. It is a sensor that is based on a very different detection technology than the GCMS, and in a very broad sense looks at the full range of chemical and human decomposition.
Which is based on the work of Arpad Voss?
In a very, very loose sense, but a technology that is used in the field, such as Labrador, has to be validated and stand on its own merit. Nobody is going to buy a field instrument just because they heard about it in a court proceeding. The people who use field technologies are very hardworking people who have difficult jobs. They're law enforcement agencies. They are first responders. They're military personnel. They do not need to have something that doesn't work. They will not buy something that doesn't work. It has to be an instrument that functions, does the job that they need, and that means it has to have its own independent validation and testing. And there is no way that anything that takes place in this court proceeding will in any way validate the Labrador.
Do you, in your patent proposal, do you deny, sir, that in your patent proposal there is a indicator that there is mention that these are validated in a court of law?
Objection. Scope of cross, relevance.
Objection sustained goes to a collateral issue.
Sir, how many times since you've been involved in this case, has the Labrador been promoted in the media for this? Since you've been involved in this particular case.
Labrador was not used in this case whatsoever. Labrador was in the process of being designed. I was developing the electronics. It did not even exist until about a year after we ran these initial samples, and I certainly had no crystal ball that says sample I'm running today is going to in any way enhance the ability of an instrument that has not been built yet or known to function yet or anything else having to do with Labrador. There is not a relationship between this case and Labrador.
Sir, are you understanding my questions? My question to you, sir, is how many times has Labrador been promoted since you've been involved in this case?
I have no idea.
But you would agree, sir, that of course it's been promoted significantly since being involved in this case.
It would have not an evidence, leading, and relevance collateral issue.
Sustained.
Now, you talked about testing all types of environmental samples, but yet this is the first time you've actually examined a carpet sample, is it not?
I did not say I've tested all kinds. I've tested a very wide variety.
But never a carpet sample?
I don't recall. It's been a while if I have.
Okay. You can't recall a single occasion where you've examined a carpet sample?
I do not recall. If I have, it's been a while back, and long enough back that I cannot specifically remember.
So you cannot emphasize on any of your experience as to what you would normally find in a carpet sample?
No, I cannot say what I would expect to find in a carpet sample. I have not personally analyzed a wide variety of carpet samples and know what is there.
And one of the other carpet samples that you got from the junkyard had chloroform in it.
It did have a small amount of chloroform in it.
Now you just said small amount.
Yes, it was.
Was that a quantitative analysis?
Interrupted.
Sustained.
The response was just a little bit above the baseline of the response of the instrument.
And did you do a quantitative analysis on that one?
It was not quantitative. I did not indicate that it was a part per million or anything else. Okay. That is a qualitative statement.
Okay, sir. And Mr. Ashton pointed out that you did research to find out about the possible explanations of chloroform. Do you recall that line of questioning?
I did look at some material data sheets, yes.
Okay. And what your research basically consisted of is you Googled a few items, right?
I looked up some material data sheets. I said it was not an exhaustive study by any stretch, just some common product that you might find in the back of a vehicle.
You Googled a few products, right?
That's right. It was not exhaustive by any stretch.
And you spent about an hour looking up, Googling items?
I don't recall exactly how long, no.
Okay. And you would certainly not base or render any opinions based on that limited amount of Googling, correct?
As I have indicated, I cannot tell from my data where any chemical comes from. I will not say that because this chemical is here, that it came from this source or this source or this source. I cannot make that determination.
And you are aware that chloroform can be found in cleaning products as well as adhesives. Are you?
I do not know where all chloroform might be. I do not have that information.
Did you find any of that in your Googling?
I did not see anything that had any chloroform in it in what I looked at, no.
And did you, my question is, when you Googled, did you find cleaning products that contain chloroform?
I did not do an exhaustive study.
Sustained.
I have no further questions.
The Labrador was designed primarily for use by law enforcement and the military. Is that correct?
Yes, sir.
And if a device is used by either one of those governmental agencies, there are no royalties. Isn't that correct?
That is correct, sir.
So this device was designed to be used by people who could not possibly pay you any royalties.
That is correct.
No further questions.
May the witness be excused.
Yes, sir.
Yes, Mr. Byers?
I just have a brief follow-up on that issue.
Well,
Wait, let me hear the question. Go ahead.
I didn't excuse the witness.
Ask your question.
Yes, sir. Sir, I didn't understand you correctly. Are you saying that if this Labrador is produced and sold, that you nor your laboratory would generate any money?
As far as my understanding of the patent process, the United States government is allowed to use any patented technology free of royalty.
And as an inventor, you would have 15% of that, would you not?
I'm just saying I would not get a royalty for government use because it would be a royalty-free use.
Federal government use?
And I don't know if that extends to state government or not. I do not know.
So if it's sold to law enforcement in Apopka, Florida, you would generate income from that?
I do not know.
It was a fact, not in evidence. Asked and answered.
Sustained.
I have no further questions.
Okay, thank you, sir. You may be excused.
Thank you.
Okay, ladies and gentlemen of the jury, this concludes the presentation of evidence for today. Please remember all of my admonitions and have a restful evening. See you tomorrow morning. May be seated. Okay, please remember what I've told you, that you need to be here at 8:30. If there are matters to take up, the court deputy will notify me and we will proceed to discuss those particular matters. At 9 a.m., the jury walks through that door to start listening to testimony. So if you have matters to bring up, you need to notify the court deputy. And at approximately 5 minutes to hour of 9, whatever arguments or whatever comments you have will cease, so we can get ready to start testimony promptly at 9 a.m. Time will be divided equally among each side. Are there any matters we need to take up prior to recessing for the evening? Okay, we'll be in recess. You'll be here at 8:30.